Students are joining. We'll start in a minute. Hello, good morning, and welcome to Baiju's Exam Prep. Yesterday, we first looked at what are the arguments in favor and against the Child Labor Amendment Act 2016. Then we jumped to right to religious freedom, where we discussed Articles 25 to 28. Then we looked at, sorry, then we looked at cultural and educational rights under Articles 29 and 30. And then we looked at Article 32, which talks about right to constitutional remedies. What are the remedies available to an individual once his or her fundamental rights are violated by the state? And there I told you that it is this Article 32 which has been declared by Dr. B.R. Ambedkar as the fundamental of all fundamental rights. Then we jump to three other articles, Article 33, Article 34, and Article 35, which basically completed our discussion on fundamental rights. But there are a couple of things that we had to discuss further. We'll discuss them. Then we will jump to part 4 of the Constitution, Directive Principles of State Policy. Now, under Article 32, one can approach the Supreme Court if fundamental rights are violated. But then one can also approach the high courts if these fundamental rights are violated. And this is what we call writ jurisdiction. What does that mean, jurisdiction? For example, there is a district collector, the head of a particular district. Now, his jurisdiction, under his control, is the entire district. Similarly, the power to issue writs for the enforcement of fundamental rights, this power is available both to Supreme Court under Article 32 as well as High Courts under Article 226. But we say this writ jurisdiction of High Courts is larger than the Supreme Court. The power to issue writs given to the High Courts is much wider, much larger as compared to the Supreme Court. Why? There are two reasons. Number one, Supreme Court cannot refuse a petition under Article 32. That means once an individual approaches the Supreme Court asking the Supreme Court to issue the writ if his or her fundamental rights have been violated, the Supreme Court cannot refuse to hear this case. Why? Because the Supreme Court is the guardian of the fundamental rights, protector of the fundamental rights. But high courts can refuse. Why? Because you approach the High Court may say that no, you rather approach the Supreme Court because Supreme Court is the protector of your fundamental rights, the guardian of your fundamental rights. That is why we say writ jurisdiction of High Court is wider. High courts can refuse, but the Supreme Court cannot. But when we look at the empirical reality, although this is what the Constitution says, this is what the established norms say, but when we look at the empirical reality, in reality, more often than not, when somebody approaches the Supreme Court alleging violation of fundamental rights, asking the Supreme Court to hear this case, sometimes the Supreme Court asks the petitioner, you should rather approach the High Court. For example, when somebody is arrested, somebody is detained, his fundamental rights are violated, these individuals, more often than not, they directly jump to the Supreme Court, ask the Supreme Court to protect their fundamental rights. And the Supreme Court sometimes say, no, you should rather take the route of the High Court, first approach the High Court, then approach us. Although the established norms say Supreme Court cannot refuse a petition under Article 32. That's number one. Number two, Supreme Court can issue writs only for the enforcement of fundamental rights. High courts can issue writs for the enforcement of any legal right as well. Including fundamental rights, including statutory rights. What does that mean? For example, your right to life, freedom of speech and expression, right to religious freedom has been violated by the state. What you can do, you can approach the Supreme Court. Supreme Court will issue writs and will protect and uphold your fundamental rights. But high courts have the power to issue these writs not only for the enforcement of fundamental rights, but for the enforcement of any right. For example, right to vote. Is right to vote a fundamental right? No. Right to vote is a constitutional right. So if somebody is denied right to vote, in a sense, his name has been deleted from the voter list, what will happen? You can approach the Supreme Court. Supreme Court will say, but there is no fundamental right violation in this case. You approach the High Court. High Court will say, even if it's a constitutional right, I will issue the writ of mandamus. And I will direct the Election Commission of India that you should include this person's name in the voter list. That means high courts can issue writs not only for the enforcement of fundamental rights, but any legal right, which can be a constitutional right, which can be a statutory right as well. For example, one more statutory right is right to information. You want to seek an information. Let's say yesterday's news. You want to seek an information. Can you please tell me the resignation letter given by Dr. Ambedkar when he resigned from the Council of Ministry in the 1950s? Can you show me that resignation letter? What are the grounds on the basis of which Dr. Ambedkar resigned? What you can do, you can approach the authorities, asking the authorities to give you the response, get that resignation letter. But if the authority refuses to give you that information, you can approach the Central Information Commission. If Central Information Commission also refuses to give you that information, you can approach the High Court. High Court can issue the writ of mandamus and may ask the Central Information Commission, give this individual the information that he is seeking. That means we are issuing the writ of mandamus, which can be issued against a public body, not only for the enforcement of fundamental rights, but for the enforcement of any legal right, which can be a constitutional right, which can be a statutory right. Its jurisdiction of the High Court is larger, wider as compared to the Supreme Court for two reasons. Number one, Supreme Court ideally cannot refuse the petition filed under Article 32, but the High Courts can refuse. Second, Supreme Court can issue writ only and only for the enforcement of fundamental rights. But what about other rights? If these rights have been violated, if statutory rights have been violated, constitutional rights have been violated, you can approach the High Court. High Court can issue these writs and will enforce, protect, guard, uphold your fundamental rights. That's the difference between Article 32 and Article 226 of the Constitution. Sir, is RTI part of 19(1)(a)? That is specific to the right of a voter to seek information about the candidate contesting the election. That right to information, right to inform about the educational qualifications of a candidate, the number of criminal cases pending against that candidate, the amount of assets in the name of that candidate and in the name of his or her spouse, that information which will help the voter to make an informed choice and decide whether to vote for this candidate or someone else. Specific to that information is your fundamental right. but so far as right to seek information from a public body. For example, how a municipality is spending its funds, how the government is spending the funds, how the government has come to a conclusion on a particular decision. This right to information is a statutory right under the RTI Act of 2005. Clear? Now let's look at some of the constitutional bodies, because constitutional bodies, their composition, their role is also a part of your syllabus. We'll discuss all these constitutional bodies one by one wherever we encounter them. And now we have encountered three constitutional bodies, because in fundamental rights, we discussed Article 15 and Article 16, where we looked at that there can be reservation for SCs, STs, OBCs in educational institutions as well as in government jobs. And for these SCs, STs, and OBCs, we have three constitutional bodies. That means bodies created by the Constitution itself. Those bodies are National Commission for Scheduled Castes, National Commission for Scheduled Tribes, and National Commission for the Backward Classes. Let's look at National Commission for Scheduled Castes. Listen to me carefully. If you understand one constitutional body, whatever we discuss about this constitutional body, same is true for other two constitutional bodies as well. Which means if you can study one constitutional body, it basically means you have covered all the three constitutional bodies, because same power, same role, same responsibility. The fact of the matter is, National Commission for Scheduled Castes and National Commission for Scheduled Tribes, previously it used to be a one constitutional body. It was one constitutional body which was taking into account SCs as well as STs. But then Constitution was amended. The year was 2003. 89th Constitutional Amendment Act was passed. Because of this, what happened? Bifurcation. A separate National Commission for Scheduled Castes was created. A separate National Commission for Scheduled Tribes was created. That means previously they were one. If we have to split the two, what we have to do? We have to amend the Constitution, because it is mentioned in the Constitution. And because of 89th Constitutional Amendment Act 2003, bifurcation of these two commissions took place. What was the purpose? There are various schemes targeting scheduled castes. For example, their skill development, for example, their employment opportunities, for example, their health, for example, nutritional standard for SCs. And these SCs may also be discriminated against. They may be subjected to torture by the police. They may be subjected to social boycott by other members of the society. That means, one, there are various schemes which are targeted at the scheduled castes to uplift them. Are these schemes working well, or do we need to fine-tune these schemes? To oversee the implementation of these schemes, that is the purpose of National Commission for Scheduled Castes. Constitution has further safeguards for SCs, that you will be provided reservation, special protection, special provision for your upliftment, reservation in educational institutions, reservation in government jobs. Are these safeguards being implemented properly, or is there something amiss? Is there something lacking? That is the purpose of this National Commission for Scheduled Castes. And this constitutional body, it will have a chairman, it will have a vice chairman, and it will have three other members. And all these members, chairman and vice chairman, they are appointed by the President of India. But President does not have the discretion. It's not that President will appoint anyone on his own. It's basically on the recommendations of the Council of Ministers, headed by the Prime Minister. Names are given to the President. Formal appointment letter is issued by the President. Just like in collegium, a judge of the Supreme Court is to be appointed, a judge of a High Court is to be appointed. Although the appointment letter is given by the President. So we say the justice is appointed by the President. Judge of a Supreme Court or High Court is appointed by the President. but that is only the formality. The real recommendation comes from the Supreme Court Collegium. Similarly, the chairman, vice chairman, three other members of this National Commission for Scheduled Caste, although they are appointed by the president, but on the advice of the Council of Ministers headed by the Prime Minister. What are their duties? All the safeguards that are available to the members of SC community by the Constitution. Investigate these safeguards, monitor these safeguards, and see whether these safeguards are working well or not. That is duty number one of this commission. Duty number two, there may be complaints. A member of the SC community may complain that I've been discriminated in my government job. I have been discriminated because I was trying to access public guard. I was trying to access means of public entertainment. I was trying to access a grocery shop. Investigate and look into all these claims of discrimination against the members of the SCs. That is another duty of this commission. And we need to plan the economic development of SCs, catering to their jobs, catering to their skill development, advising the government how and what sort of policies should you implement so that we lead to economic development, skill development of the members of the SC community. That's another duty of this commission. Another duty is the most important one. Whatever complaints have been received by this commission, whatever violation of the safeguards that are mentioned for SCs in the Constitution have been violated, for all these things, this commission will prepare a report. And then this report is sent to the president. And it is binding on the president that what you have to do, you have to table this report in the parliament, so that the entire parliament, and through the parliament, the entire nation will come to know what are the recommendations of this commission which have not been accepted by the government. What are the complaints that this commission received, and what action was taken by the government against those complaints. All these reports will be prepared by this commission, will be presented to the president, and then it will be prepared and planned before the Parliament of India. Another role is to make recommendations that should be taken by the union or any state for the effective implementation of those safeguards which are mentioned in the Constitution. That means this commission will not only make recommendation to the union, to the central government, but also to the states. How can you better implement the policies and the programs for the upliftment of the SC community? Similarly, any other role can be given to this commission by either the president or the parliament. Parliament may give additional role to this commission. President may give additional role to this commission. That means apart from, for example, apart from recommending the government, you may also recommend what is the percentage of reservation that we should be giving to SCs. Although right now that's not the power, but tomorrow that also can be given to this National Commission for Scheduled Castes. And when it functions, it has some powers. And those powers are that when this investigation is carried out by this commission, it will have the power of a civil court. What do we mean by civil court? For example, the court has issued you a summon that you should be presented before the court. You have to give us certain answers. Similarly, can you refuse to go and appear before the court? You can't, because then punishment will be given to you. Police may even tell you, the court can even tell the police, arrest this individual because he has failed to appear before us. Similarly, if this National Commission for Scheduled Castes, it comes up with a complaint against an organization because this organization is discriminating against SCs. This organization is segregating people into SCs and non-SCs, giving them not access to food, discriminating against them, practicing untouchability, for example. The commission may ask that organization or the CEO of that organization, even if it's a private organization, that you come and appear before us and explain your stand, explain your position. Why are you discriminating? Because there is an allegation of discrimination against you. And if that CEO of that organization refuses to accept, refuses to appear before this commission, because now the commission has the power of a civil court, it may even direct the police, arrest that individual and bring that individual before us. Because while investigating, while conducting inquiry into the allegations against SEs, this commission will have the power of the civil court. And it shall be the duty of the union and every state government to consult this commission on all major policies which affect the scheduled castes. Any major policy which affects the scheduled caste, whether it is dealing with education, employment, skill development, atrocities, you will have to consult this commission. That's the power of this commission. It can summon, as I said, and enforce attendance of any person before the commission. It may also require discovery and production of documents. This commission may ask that CEO, can you show us the documents that you have prepared, where you can clearly tell us that you are not practicing untouchability? Because some of the mails that you have sent, some of the circulars you have sent, some of the communication that your office has sent, it clearly tells us that you are practicing untouchability. Produce all the documents that you have before us. You may also tell us that how many employees do you have who are from SC community, because we can then see whether you are discriminating against SCs or not. That means this National Commission for Scheduled Castes, it is basically a constitutional body, but previously this body and the body for STs, it was one and the same. Then in 89th Constitutional Amendment Act 2003, bifurcation took place, which means one body for SCs, one National Commission for STs. What is the role? What is the responsibility? What is the composition? What are the powers of this commission? That is something that you need to understand for your civil services examination. All these powers, which we have discussed for National Commission for Scheduled Castes, same provisions, same composition, same responsibilities. All you have to do, replace SCs with STs. In a sense, National Commission for Scheduled Tribes, it is to be consulted by the union and the state government on all major policies affecting the scheduled tribes. Similarly, all the allegations of discrimination against STs can be inquired by National Commission for Scheduled Tribes. National Commission for Scheduled Tribes will also advise the state and the central government what are the steps that you should be taking to uplift the ST community. Same power, same role, same responsibility. All you have to do, replace SCs with STs. And you have to replace SCs with backward classes, OBCs. And that will remain true for National Commission for Backward Classes. But National Commission for Backward Classes, previously it was a statutory body. That means it was a body which was created by the Act of the Parliament. The year was 2018. Because of the 102nd Constitutional Amendment Act, this National Commission for Backward Classes, it was converted from a statutory body into a constitutional body. What is the significance? What exactly happens if a body is made constitutional? Because this body previously was statutory. If it's a statutory body, Parliament will have less oversight of this commission. That means this commission may give its report to the president and president may not table it on the floor of the Parliament. This commission may give some powers, but these commissions may have some powers, but these powers may be snatched by Parliament later or reduced by Parliament later. But if this commission is mentioned in the Constitution itself, that means whatever report is prepared by this commission will have to be tabled on the floor of the Parliament. When it is tabled on the floor of the parliament, that means there will be a discussion in the parliament on that report. When there is a discussion on the parliament on that report, ultimately questions will be asked to the government. What have you done or not done to implement this report? That means this report will have more and more visibility, which means more protection available to that group whose body is now a constitutional body created by the constitution. And that is what happens when a body is converted into a constitutional body, if it was previously a statutory body. But something else happened. What happened? For example, the list of SCs, the list of STs. How many caste groups are in SCs? How many caste groups are there in STs? Who has the power to add castes into this list? That's the power given to the central government. Only the central government has that power. But what about OBCs? Previously, states and union territories had its own OBC list, and center had its own OBC list. That is why if you belong to OBC category, you may see that sometimes your caste gets reservation in the state but no reservation at the center. That means castes which belong to the OBC category, states and union territories have their own list, center has its own list. But when this National Commission for Backward Classes was constituted as a constitutional body in 2018 because of 102nd Constitutional Amendment Act, then matter went to the court. Now, who has the power to add castes into the OBC list? Should we have only one list which will have all the OBC castes mentioned, and the same list will be followed by the center as well as all the states? Or should we have a separate list of OBCs in a state, separate list of OBCs at the center? The court said no, you can have only one list. Why? Because just like SCs and STs, we have one list. SCs at the center and all the states, same. STs at the center and all the states, same. And this list is prepared by the central government. President has the power to add lists, add castes into SCs, remove tribes from the STs. That's the power available with the central government. Same role will be that of National Commission for Backward Classes as well. Because I told you, all these three commissions, they have the same composition. Members will not be same. Composition will be same. That means they will have a chairman, vice chairman, and 3 members. Separate members for SCs, separate for STs, separate for National Commission for Backward Classes. And I told you, all the powers, all the duties, all the functions are same. All you have to do, replace SCs with STs, and question is clear. Replace STs with BCs, National Commission for Backward Classes, and the answer is clear. And the same way, the Supreme Court also said that if for SCs and STs, the list is prepared by the center, for backward classes as well, OBCs as well, the list will be prepared by the center. States will have no role whatsoever. That means this list, consisting of members of SEBC, who are these SEBCs? Socially and educationally backward. The states and union territories will not have the power to keep and prepare their own lists. Now, Parliament, after this judgment, amended the Constitution again. And that is 105th Constitutional Amendment Act, which came into force from the 15th of August 2021. And this Constitutional Amendment Act said that OBCs will have a separate list of socially and educationally backward class of citizens prepared by states and union territories. There will be a separate list prepared by the central government. This list will be applicable for the union level appointments. This list will be applicable for the state level appointments. For example, when the state government is advertising posts, announcing jobs, then giving reservation to those OBCs which are mentioned in the state list. But when the central government is advertising jobs, posts, applications, then those OBCs which are part of the central list, they will get the reservation benefit. So center will have its own list. States and union territories can have their own list of socially and educationally backward class of citizens. This is the only difference that National Commission of Backward Classes has with other two commissions, SCs and STs. And that brings us to the closure of Fundamental Rights chapter. Any questions, let me know, then we will jump to DPSPs. Okay. Let's now look at part 4 of the Constitution, Directive Principles of State Policy. As the name suggests, what are the principles that direct the state when the state is making policies? What are the principles that the state has to keep in mind when the state is enacting laws, when the state is making policies? All those principles are known as directive principles of state policy, which come under part 4 of the Constitution. We say these directive principles, they contain positive obligation of the state. What is that positive obligation? Article 1 to 4 deals with part 1, which is union and its territory. Article 5 to 11 deals with part 2, which deals with citizenship. Articles 12 to 35 deals with fundamental rights, which are part of part 3 of the Constitution. Article 36 to 51 deals with directive principles of state policy, which are part of part 4 of the Constitution. What is Article 36? It is similar to Article 12. What is Article 12? Article 12 talks about the definition of the state, that these fundamental rights are enforceable against the state. If the state is violating these fundamental rights, you can drag the state to the court, because these fundamental rights are your claims against the state. Now, who is the state? What constitutes state? That is mentioned under Article 12. In the similar fashion, when we say directive principles of state policy, what are the principles that direct the state when the state is making laws, when the state is creating policies? Those principles are what we call directive principles of state policy. But who is this state? The definition of the state is given by Article 36 of the Constitution. And this definition of the state is the same as the definition of the state under Article 12 of the Constitution. That means whatever is the definition of the state under Article 12, same is the definition of the state under Part 4 of the Constitution given by Article 36. And all other DPSPs from Article 37 to 51, we say they contain positive obligations on the state. What are these positive obligations? I'll take you back to the first discussion we had on fundamental rights. And I told you that there are 3 parts of the Constitution. Although separate, distinct units. Part 3, fundamental rights. Part 4, directive principles. Part 4, capital A, fundamental duties. Although these are separate, distinct units, separate from each other, yet combining them together, what do we achieve? The objective is to implement, give shape, concretize the lofty goals that are mentioned in the preamble. So justice, liberty, equality, fraternity, dignity of an individual, if we want to implement, that we can implement through these three different parts of the Constitution. And in fundamental rights, I told you these are negative obligations on the state. The state is asked, do not interfere, don't discriminate, don't deny equality, don't do this, don't do that. What's that? Doctrine of limited government, which means the powers available with the state, they are not unlimited. There is a limitation on the powers of the state. That is why we say fundamental rights are negative obligations on the state. Don't discriminate, don't deny equality, don't violate the dignity of an individual. But these directive principles are positive obligations. Here we are asking the state, please come and interfere so that the gulf between the rich and the poor is minimized. Please come so that we can implement social and economic democracy. Because for the promotion of political democracy, we have fundamental rights. For the promotion of socio and economic democracy, what do we have? We have directive principles of state policy. So we are asking the state, in directive principles of the state policy, please interfere so that we can establish a welfare state. What is a welfare state? Here is a state, and then there are people. Simple analogy. There is state watching over all the people in India. Some are rich, some are poor. Some are healthy, some have some defects, some are suffering from some ailments. Some have livelihood opportunities, some don't. Some have educational opportunities, some don't. What will the state do? Will it act as a mute spectator and not involve itself? Will it not interfere? The state will interfere. Why? So that it leads to welfare of all. That means not only rich, even the poor are uplifted. So state will make policies for the upliftment of the poor sections of the society. Maybe give them scholarships, maybe give them loans on cheaper rates, but will interfere to uplift them. There are those who cannot afford medical costs. What do? Should we let them die? No. The state will provide insurance, medical insurance to them, free hospitals for them, free admission in hospitals for them, maybe free medicines as well. Why? Because the state exists for everybody, not only for those who are healthy, but also those who are suffering from some ailments. That means we are asking the state to interfere so that it leads to welfare of every single section of the society. That's the idea of a welfare state. And this idea of a welfare state is different from a laissez-faire state. What is a laissez-faire state? A country which is a laissez-faire economy. There the state does not interfere in economic policies. Economic policies, for example, what you produce, at what cost you produce, how much you produce, what is going to be your economic policy, state will not interfere. State will look into political sphere, state may look into social sphere, state may look into any other area, but for economic sphere, state will disappear, state will not interfere at all. That's a laissez-faire economy. Singapore is an example. Hong Kong is an example of laissez-faire economy, where in economic matters, the state allows the market forces to determine everything. But when it comes to a welfare state, we say the state interferes, even in economic matters. Even in economic matters, the state can impose more taxes on the rich, so that whatever we get from these taxes, whatever revenue we generate from these taxes, we can give it to the farmers. We can give it to the weaker sections of the society. It's like state acting like a Robin Hood. That is the idea of a welfare state. Long story short, Part 4 of the Constitution talks about directive principles of state policy. In simple terms, what are those principles that the state has to keep in mind, which direct the state, when the state is enacting laws, when the state is making policies, those are what we call directive principles of state policy. And we say Article 36 is similar to Article 12. Now, isn't this duplication? No. You have to be clear at every step so that tomorrow there is not dispute. There is no dispute. Tomorrow you may not go to the court, but DPSP's state definition should be different. It can't be the same as that of fundamental rights. Just for that clarity, Constitution has said when we use the term state under Part 4, its definition is same as that of Article 12 of the Constitution. And then we say all these DPSPs, these are basically positive obligations of the state, asking the state, please interfere so that we can establish a welfare state, a society which exists for everybody, not only for rich and the affluent sections of the society, for everybody. And we have borrowed these DPSPs from the Irish Constitution, from the Constitution of Ireland. Another important detail, DPSP denotes the ideals that the state has to keep in mind when the state is making policies, when the state is enacting laws. And the idea of DPSP is to establish a welfare state, a state which exists for everybody. But then there are two important characteristics of DPSPs. These characteristics are mentioned under Article 37 of the Constitution. What are these characteristics? Number one, these DPSPs are not enforceable in a court of law. What do we mean by that? That means these are non-justiciable. What do we mean by that? Fundamental rights are justiciable, which means they are enforceable in a court of law, which means if your Article 14, if your freedom of speech and expression, if your religious right is violated, what is the option available to you? You can knock the doors of the court will protect your fundamental rights. That means your fundamental rights are enforceable. They can be enforced in a court of law. If the state is violating your fundamental rights, not giving you your fundamental rights, you can approach the court will enforce your fundamental rights, which means fundamental rights are justiciable, which means fundamental rights are enforceable in a court of law. But DPSPs are not enforceable in a court of law, which means if these DPSPs are not implemented by the state, if these DPSPs are violated by the state, you cannot go to the court. Sir, why is that the case? I'll tell you towards the end. Towards the end, I will tell you why these DPSPs are not enforceable in a court of law. That doesn't mean these DPSPs are inferior. There is some other reason behind their non-enforceability, their non-justiciability. What is that reason? I'll tell you slightly later. But here, just keep in mind, these are not enforceable in a court of law. Sir, can you give an example? For example, one such DPSP is implementing Uniform Civil Code. Now, Uniform Civil Code has not been implemented since 1950. Can you go to the court and say, my lord, DPSP has been violated? Which DPSP? Sir, Article 44 of the Constitution. Which Article 44? Sir, the state has failed to implement Uniform Civil Code. Then why are you here? Sir, we are here so that you can tell the parliament, please enact Uniform Civil Code. So that you can tell the government, please enact a Uniform Civil Code. The court will say this petition is dismissed. Why? Because it is part of DPSP. DPSP is not enforceable in a court of law. We cannot direct the parliament. We cannot direct the executive to implement these DPSPs. Why? Ask your polity teacher. He will tell you at the end of the class. Clear? Right now, keep in mind, these are not enforceable in a court of law. That's characteristic number one. Number two, even if these DPSPs are not enforceable in a court of law, Article 37 says it shall be the duty of the state to implement these directive principles of the state policy, because these DPSPs are fundamental for the governance of the country, for the fundamental growth of a country, For governance of the country, it is necessary, it shall be the duty of the state to implement these directive principles of state policy. So there are two characteristics spoken about by the Constitution under Article 37 related to directive principles of state policy. One, they are not enforceable in a court of law. Why? I'll tell you later. Second, it shall be the duty of the state to implement these directive principles of state policy, because these DPSPs are fundamental for the governance of the country. Clear? Done? Let's look at something else. When we look at all these DPSPs one by one, beginning with Article 38 to Article 51, you don't have to remember, you don't have to memorize these DPSPs. Don't do that. That's a waste of time. Please don't. There are some DPSPs which you must remember, and I will point out those DPSPs. I'll tell you that these are the DPSPs that you must remember. But please don't waste your time in memorizing Article 38 to 51. What is Article 36? Definition of the state. What is Article 37? Two important characteristics of DPSP. They are not enforceable in a court of law, yet they are fundamental for the governance of the country. Then the real DPSPs start with Article 38, they end with Article 51. When we look at all these DPSPs between Article 38 to 51, we get a sense. What is the sense that we get? That some of these DPSPs, they reflect the ideology of the Mahatma Gandhi. So we call them Gandhian principles. When we look at other DPSPs, we see that these are reflecting the ideology of Karl Marx and Marxian concept of socialism, which we have discussed in preamble. Those principles can be called socialistic principles. And then there are other DPSPs which reflect some contemporary liberal intellectual principles. Those are what we call liberal intellectual principles. Listen to me carefully. DPSPs, some of the DPSPs are socialist, some are Gandhian, some are liberal intellectual. This differentiation is not created by the Constitution. So Constitution does not say that these are DPSPs from Article 38 to 51 and these are Gandhian, these are socialist, these are liberal intellectual. No, Constitution has not categorized, classified DPSPs into Gandhian, liberal intellectual or socialist. Who are these people who have then classified these DPSPs? Constitutional experts. Constitutional experts, by looking at these DPSPs, they get a sense that some DPSPs reflect the idea of Mahatma Gandhi, reflect the socialist principles, reflect the liberal intellectual principles. So constitutional experts have categorized, differentiated DPSPs based on liberal intellectual, socialist and Gandhian principles. Constitution does not say that these are liberal, these are socialist, these are Gandhian. Now there is an assignment for you. What is the assignment? Look at Article 38 to 51. All these, did we cover the topic fundamental duties? We'll cover fundamental duties after DPSP. So we'll go by part. Preamble, Part 1, Union and its territory, we have discussed. Part 2, citizenship, we have discussed. Part 3, fundamental rights, we have discussed. Part 4, DPSPs, we are discussing. 4, capital A, fundamental duty, will be discussed after this. Clear? There is an assignment for you. Take a look at all these DPSPs between Articles 38 to 51. Without reading them, without researching them, see if you can make out that whether this DPSP is a socialist or Gandhian or liberal intellectual principle. Because this can be a question in your prelims examination. Which of the following DPSPs reflect Gandhian principles? Which of the following DPSPs reflect socialistic principles? Which of the following DPSPs reflect liberal intellectual principles? Even without reading these DPSPs, Even without going through these DPSPs one by one, can you make out whether a DPSP deals with Gandhian, liberal, intellectual, or socialist? Yes, if you understand the ideology. What is the ideology? For example, you tell me all the workers of the factories must be involved in the management of the industries. What would this directive principle be? Under what category will this directive principle come? Very good. Socialist principle. Why? Because it's the idea of Karl Marx, socialism. Because he looked at capitalism from very close quarters. And he said that in capitalism, workers are forced to work in inhumane conditions. So, any principle which gives power to the worker in the management of the industry, it's a socialist principle. Equal pay for equal work. What sort of directive principle would this be? Socialist principle. Why? Because it talks about workers, it talks about the Karl Marx's concept of socialism. All the material resources that we have, what are the material resources? Land, for example. It must be distributed in such a manner that it does not lead to concentration of wealth in fewer individuals. What sort of directive principle would this be? Socialist principle. Why? Because it reflects the Karl Marx's idea of socialism. Everybody is right. Chaitanya, Neil, Tulsi, Utkarsh, Harisha, Deepika, everybody. So even without reading these DPSPs, by looking at them, by reading them, if you have understood the concept of socialism, you can make out that this DPSP reflects socialistic principles. But if there is a directive principle which talks about that there should be a ban on intoxicating drinks such as liquor, under what directive principle would this come? Gandhian. Why? Because Mahatma Gandhi was against liquor. That is why in his home state, Gujarat, liquor was banned for many, many decades. And it is still banned. If there is a DPSP which talks about organization of village panchayats, what sort of DPSP would this be? Again, Gandhian principle. Why? Because Mahatma Gandhi believed that India lives in the villages. And if a village becomes self-sufficient, India as a nation would also become self-sufficient. That is how he started a beautiful program at Wardha, community development program, Wardha scheme, which we will discuss in modern history. But if there is a principle, DPSP, which talks about separation of executive from judiciary, what sort of directive principle would it be? Liberal principle. If there is a directive principle which talks about giving educational opportunities, what sort of directive principle would it be? Liberal intellectual. If there is a directive principle which talks about preserving wildlife, monuments, our heritage, it's a liberal intellectual principle. If there is a principle which talks about taking into account the interests, the claims of the members of the SC and ST community when it comes to employment opportunities, that's a Gandhian principle, because Mahatma Gandhi started with Harijan Seva. Mahatma Gandhi said, these Harijans, who are the children of God, whom you are calling Shudras or Dalits, whom you are calling untouchables, these are basically children of God, and we have to preserve them and we have to help them. If we do not help them, Hinduism will collapse, according to Mahatma Gandhi. So for those who belong to SC and ST community, the safeguards that are there in DPSPs, they are part of Gandhian principles. So what you have to do, look at these DPSPs from Article 38 to 51 after the class is over. Take a look at these DPSPs from Lakshmikant book and then mark whether this is Gandhian, liberal intellectual, or socialist. And then match it with this number, with this list that I have provided. Whether Article 40 is Gandhian or liberal intellectual, whether Article 39 is socialist or Gandhian. And you will realize that there are some DPSPs which are similar. Similar in the sense which are both Gandhian as well as socialistic principles. Why? Because I've told you in the previous classes that idea of Mahatma Gandhi and the idea of Karl Marx more or less is similar. It's the approach that they take which varies. Mahatma Gandhi believed in non-violence, so society can be changed without violence. But Karl Marx, when he was young, he was in favor of revolution, and revolution can be bloody as well. That's what Karl Marx said. All the workers of the world unite. What is communism for Karl Marx? A stateless society. That's Ram Rajya for Mahatma Gandhi, a stateless society. So they have much, much, much in common. So take a look at all these DPSPs, mark them into liberal intellectual, socialist, and Gandhian, and then you will see that sometimes there is an overlap. And that would be important for your examination. Clear? Sir, a DPSP can't be of both Gandhian and socialist. Can be. That's why I told you there is an overlap between the idea of Mahatma Gandhi and Karl Marx. And some DPSP can be both Gandhian as well as liberal intellectual. That means one half of this DPSP may reflect the ideology of Mahatma Gandhi, the other half may reflect the ideology of the liberal intellectual principles. For example, organizing animal husbandry on scientific lines, science, liberal intellectual. But ban on milch cows, cattle, it's part ban on cow slaughter. It's part of a Gandhian directive principle of state policy. Clear? Okay. But then there are some directives which are directives to the state, that means which the state has to keep in mind. But these directives are outside Part 4 of the Constitution, not under Part 4, outside of the Part 4. Where? For example, Article 335. Something we have discussed. Can you tell me where? When we discussed the reservation in public employment for OBCs. In Indra Sani case, Supreme Court said reservation for OBCs is constitutional. But for that, you have to meet 5 constitutional requirements. Prove to us that these are socially and educationally backward. Prove to us that they are not adequately represented in the administration. And you have to apply creamy layer. And at the same time, reservation cannot exceed 50%. And all of this is possible subject to Article 335. What is Article 335? There will be claims. Claims by whom? Members of SC and ST community. They will claim government jobs. And the state shall keep in mind their claims. The state shall keep their claims into consideration, but with maintaining efficiency in administration, without sacrificing merit, without flirting with the efficiency in administration. That is a directive to the state. State, there is a directive for you. Yes, sir. There will be claims by SCs and STs. You have to take their claims into consideration when you are announcing government jobs. Please take their claims into consideration. But listen to me. Do not flirt with the efficiency in administration. Do not compromise with the merit. That is a directive for you. Not under Part 4, outside of the Part 4, under Article 335. There is another directive under Article 350, capital A. Every state, every local authority of that state. Tamil Nadu, come here. Yes, sir. Local government in Tamil Nadu, Panchayati Raj institution, urban local body, come here. Said, what? There are people from linguistic minorities. Who are these linguistic minorities? Maybe Marathis who have now traveled, who are now migrating to Tamil Nadu. So these are Marathi linguistic minorities in your state. Okay, what do we have to do? It's a directive for you. So what's the directive? You have to ensure that you teach their kids in their own mother tongue. What is their mother tongue? Sir, Marathi. Till primary stage, teach them in Marathi. That's a directive for you. So under Article 350, capital A, it shall be the endeavor of every state and every local authority within the state to provide adequate facilities for instruction in the mother tongue at the primary stage of education belonging to the children of linguistic minority groups. You might say, sir, what is the point in having these directives outside of the part 4 and not part 4 of the constitution? Part 4 are not enforceable in a court of law. Directives outside part 4 are enforceable. Enforceable in the sense, if this Tamil Nadu government, or why Tamil Nadu government, let's say it is UP government. In UP government, in UP state, there are Tamil minority, linguistic minority. Yogi Baba and all the local institutes in UP, it shall be a duty on you. It's a directive for you. What's the directive? These Tamil minority, provide them education till their primary stage, till the 5th standard in their own mother tongue. And if the UP government fails to do that, then UP government may be dismissed. President's rule may be imposed in UP under Article 356 of the Constitution. That's why we say directives outside Part 4, such as 350 capital A, they are binding on the state. State cannot refuse to accept these directives. Similarly, there is Article 351. You may have heard allegations from Dr. Shashi Tharoor, from politicians from South, that this government is blatantly promoting Hindi at the expense of other beautiful regional languages. Why Mr. Modi always speaks in Hindi? Why not in other languages? Why, when our whenever ministers and prime minister travels to United Nations, they speak in Hindi or in Hindi language? They are blatantly promoting Hindi. All India radio bulletins in Hindi, and Mr. Amit Shah says Hindi is the driving language. We'll have to bind the country together using Hindi. Is this unconstitutional? No. Why? Because under Article 351, a duty has been imposed on the union, not on the state, on union. It shall be the duty of the union. What is that duty? To promote the spread of Hindi language and develop this language so that it is this language which becomes a medium of instruction for all the elements of the composite culture of India. If there is one language which can become the medium of expression for the entire country, that language is Hindi, and that shall be the duty of the state, which basically means the duty of the union, not the individual state, to promote. Long story short, Article Part 4 of the Constitution, Directive Principles of State Policy. What are the principles? What are the ideals that the state has to keep in mind when the state is making laws, when the state is enacting policies? Those are what we call directive principles of state policy. That means whenever the state has to make laws, it has to take into account the weaker sections of the society, marginalized sections of the society. Because what is the objective? The objective is to establish a welfare state, a state which exists for everybody. But there are two characteristics of DPSPs. One, they are not enforceable in a court of law, but nevertheless, it shall be the duty of the state to implement these directive principles, because these DPSPs are fundamental for the governance of the country. And these DPSPs from Article 38 to 51, if we have to segregate them, we can segregate them, classify them, categorize them into Gandhian, socialist, and liberal intellectual principles. But then there are some directives which are directives to the state. State has to keep in mind, but those are outside of the Part 4 of the Constitution. For example, Article 335. For example, Article 350 capital A. Similarly, Article 351. And any questions as of now? Let me know. Uniform Civil Code, important, very important. We have not completed DPSPs. The real DPSP starts now. This was just the introduction. Any questions? Yes, no, maybe. Okay. Directive principles are fundamental for the governance of the country, but they are not enforceable in a court of law. Nevertheless, it shall be the duty of the state to implement these directive principles of state policy. Now, what if the state wants to implement directive principles of the state policy, but in the process, fundamental rights are violated? Which means by implementing DPSPs, fundamental rights may be violated. Then what is the position? What is the relationship between fundamental rights and directive principles of state policy? For that, let's understand. The year was 1951. We have discussed this case, but let's discuss in a different angle. Champak Dorairajan versus State of Madras, 1951. What happened? Madras government issued an order, and through this order, Madras government said there will be a reservation in educational institutions, government engineering and medical colleges for those who belong to SC and ST community. Matter went to the court. The state of Madras was asked, what are you doing? Said, we are implementing directive principles of state policy. Said, what directive principle of state policy? Sir, we are implementing Article 46 of the Constitution. What is Article 46 of the Constitution? Article 46 basically talks about that it shall be the duty of the state, that what state you have to do, DPSP is direct the state, that what states you have to do, you have to take steps to provide support for socially and educationally backward classes of citizens, which means SCs and ST community. You have to take steps for promoting them, for protection of these members of SC and ST community, to safeguard their interests. And for that, to implement Article 46, what we are trying to do, we are providing reservation in government engineering and medical colleges to the members of SC and ST community. Petitioner said, but Article 46, which is a directive principle of state policy, it violates Article 15, which is a fundamental right. Can fundamental rights be violated if the state wants to implement directive principles of state policy? Madras government said yes. Why? Because Article 37 makes it clear that DPSPs are fundamental for the governance of the country. We are implementing DPSPs, which the Constitution says it shall be your duty to implement these directive principles of state policy. So we are implementing Article 46 of the Constitution. Supreme Court said, yes, you can implement all these DPSPs, but don't you dare violate fundamental rights. Why? Because these DPSPs are inferior. Fundamental rights are superior. Fundamental rights cannot be violated by the state under any circumstance. So if you are trying to give effect to directive principles of state policy, such as Article 46 of the Constitution, but don't you dare violate fundamental rights under Article 15 of the Constitution, because DPSPs are inferior, fundamental rights are superior. That's the relationship between the two. And you would know what happened after this. After this, Constitution was amended. First Constitutional Amendment Act, what it did, it added Article 15 Clause 4, and it was this Article 15 Clause 4 which allowed the state to reserve seats for SCs and STs in educational institutions. That means DPSPs cannot violate fundamental rights. And basis this judgment, Champak Dorairajan versus State of Madras, two other important pieces of legislation. Zamindari Abolition Act, 1951, and Land Reforms Act. Both were declared unconstitutional. And this time, this case was declared by a Patna High Court, by the High Court in Patna. Why? For that, we need to understand two important DPSPs. And these are the two DPSPs that you must memorize, you must remember. Article 39 Clause B, Article 39 Clause C. What is Article 39 Clause B? The ownership and control of material resources should be distributed so as to subserve the common good. What are the material resources that we have? Material resources such as land, such as spectrum, airwaves. These are material resources. These can be distributed by the state in such a manner that it leads to happiness, maximum happiness for the maximum number of people, so that it leads to larger public good. That's DPSP 39 Clause B. I'll explain it further, but let's stop it here. 39 Clause C. The operation of the economic system does not result in the concentration of wealth and means of production to the common detriment. What are these two DPSPs? These are the principles that the state has to keep in mind when the state is making laws, when the state is enacting policies. These are the two DPSPs, which means number one, land, for example, which is your material resource, which is a resource, it can be distributed by the state in such a manner that it leads to larger public good. You cannot distribute this land only to one select group of people and leave the rest. It will not lead to larger public good. An economic system that we may want to use, this economic system can be feudalism. This economic system can be socialism. This economic system can be communism. This economic system can be capitalism. This economic system can be any ism. But whatever system you want to use, it should not result in a situation where rich are becoming richer and the poor are becoming poorer, remaining poorer. It should not lead to a situation where there is a wide gulf between rich and the poor. It should not lead to a situation where some people have monopoly, which is in detriment of others. That cannot happen. And to implement these two directive principles of state policy, the Parliament of India enacted two major beautiful laws known as Zamindari Abolition Act and Land Reforms Act. Why? Because it was the promise of the Congress Party. Congress Party during the freedom struggle, Congress Party said, workers, those who till the land, tillers of the land shall be the owners of the land. Because there were these landlords. These landlords controlled massive areas of land, but they were not working on these lands. Agricultural laborers were working on these lands. So there was a select group of rich zamindars who controlled the massive material resource, which is land. Now this material resource, using our economic system, it should not result in a situation where some people have access to all the land. They have controlled every land to the detriment of others, where others do not have access to land. Congress Party said, once we get independence, we will abolish this zamindari system. All these zamindars, their titles will be abolished. Their land will be snatched by us. Socialism. And then we will distribute this land amongst the poor, landless laborers. So first, we will abolish the zamindari system. Now, once zamindar is abolished, that means these zamindars will not be the owners of these lands. And then these lands will be distributed. Land reforms will be implemented. Why? To implement two important directive principles. The ownership and control of material resources shall be so evenly distributed so that it leads to larger public good, common good. So this material resource, which can be land, distributed so that it leads to larger public good. And whatever economic system you use, it should not result to concentration of wealth and means of production to a common detriment in fewer hands. And to implement these two directive principles of state policy, Parliament enacted the laws, Zamindari Abolition Act, Land Reforms Act. Matter went to the Patna High Court. Patna High Court said unconstitutional. Said why? Because these laws, they violate Article 14, 19, and 31. Even if you want to give implementation to two directive principles under Article 39B and 39C, but in the process, you are violating three fundamental rights under Article 14, 19, and 31. Directive principles are inferior. Repeat after me. Directive principles are inferior. Fundamental rights are superior. Don't you dare violate fundamental rights. Again, the position is clear. Relationship between fundamental rights and DPSPs, fundamental rights are superior, directive principles are inferior. What is Article 14? We know that. What is Article 19? More specifically, Article 19(1)(f). What is Article 19(1)(f)? A right to every citizen. That's why I told you that Article 19, Article 31, we will discuss in Directive Principles of State Policy. Article 19(1)(f) gives a fundamental right to an individual citizen of India that I have the right to acquire property. I have the right to dispose of this property as well. I have the right to acquire property. I have the right to sell this property as well. Clear? But here, I am the owner of this land. But who is selling this land? Not me, the state. So you are violating Article 19. You are violating Article 14 as well. How can you deny equality before law? Law should treat everybody equally. But here you are snatching something from us and you are giving it to other sections of the society. You are violating equality before law. That's what the petitioner said. And you are violating Article 31 as well. What is Article 31? Article 31 basically talks about acquisition by state. State can acquire your property. Now listen to me carefully. There is something known as doctrine of eminent domain. What is doctrine of eminent domain? This doctrine is not mentioned in the Constitution, but it says that the state can acquire private land, private property, private organization for the larger public good. For example, we have to lay down a railway line. It passes through a land which is owned by you. I, as a state, I have the right to acquire this land. Why? Because it will lead to larger public good. I have that right. And this right is recognized. You are a sovereign state. That means you have the right to make a decision, unmake a decision, you are sovereign. But Article 31 said when you acquire this land, when you acquire this property, when you acquire that organization, you have to pay compensation. This right to get compensation when your property has been acquired by the state, this is your fundamental right under Article 31 of the Constitution. Now the government is in a fix. Why? We want to abolish the zamindari system. That means first we want to acquire their land. Article 14 we can somehow manage. We can say equal protection of the laws, which means laws should treat people in different circumstances differently. So you are zamindars, we will treat all zamindars equally. We will treat all the landless laborers equally, and we will distribute their wealth to them. So Article 14 can be taken care of. But Article 19 is an issue. Article 19 says you have the right to acquire property, dispose of property as well. But here, these zamindars are not disposing of property. It's the state which is disposing their property. That's the tricky part. Yes. And Article 31, yes, we can acquire their property, their land, their organization, their estate, but we have to provide them compensation. And how can we provide them compensation? We are very poor right now. British snatched and drained all our wealth. We are now one of the poorest nations of the world. So what do? Pandit Nehru called his lawyers, attorney general, legal experts. What do? Said there is no other option. But let's amend the constitution. Okay, we'll amend the constitution. But what will we do? So let's amend the constitution and add Article 31 capital A to the constitution. Okay, what will it say? It's a acquisition by the state of any estate shall not be deemed to have violated Articles 14, 19, and 31. Come again, what? Sir, we can write in the constitution itself that when the state is acquiring estate, these big lands of these zamindars, this acquisition will not be deemed to be violative of Article 14, 19, 31. Sir, I don't understand. Sir, look at Article 4 of the Constitution. Yes. There in Article 4, we say if a law is passed under Article 2 and 3, it will make changes to Schedule 1 and Schedule 4 of the Constitution. But these changes shall not be deemed as amendment of the Constitution. That means although you are amending the Constitution, but it will not be deemed as amendment to the Constitution. Okay. In the similar fashion, when the state is acquiring property, estates of these people, we can say that Constitution itself says it does not violate 14, 19, 31. Okay, very good. So let's add Article 31 capital A. When the state acquires the property, when the state acquires the estate, it shall not be deemed to be violative of Article 14, 19, 31. Pandit Nehru said, I'll go to the parliament, I'll amend the constitution, thank you. Pandit Nehru was told, sir, please listen to me. He said, what? This is only half solution. Okay. Sir, we need another half as well. So what is that? What if tomorrow judiciary questions this? What? Judiciary questions, how can you do this? How can you pass such a law and say it is not violative of Article 14, 19, 31? Because judiciary can strike it down. I said, yeah. That's what Patna High Court said. Yes. That's what Champak Dore Rajan case said. Yes, yes. So what do? So let's amend the constitution again. What do? So let's add Article 31 capital B. What is Article 31 capital B? Any law which is placed in 9th schedule, there shall be no judicial review. So Article 31 capital B will create a 9th schedule. Yes, sir. How? Sir, look at Article 1 of the Constitution. All the states and territories thereof shall be mentioned in first schedule. So schedule is something which requires more explanation. Any article, if it requires explanation, we add a schedule. So 31 clause B, 31 capital B will be an article which will create schedule 9 of the Constitution. Then what will happen? Any law which is placed in 9th schedule, we cannot say that this law violates fundamental rights. And there is no judicial review possible. Judiciary cannot question the law which is placed in 9th schedule. You're basically trying to say that we will pass Zamindari Abolition Act again. Yes. We will pass Land Reforms Act again. Yes. And we will say that these laws which acquire property shall not be deemed to be violative of Article 14, 19, 31. Yes, sir. And then the same laws we will place in 9th schedule. Yes, sir. Which means any law which is placed in 9th schedule, judiciary cannot question it. Yes, sir. Fantastic. Let's do that. And that's how the constitution was amended. That's how ninth schedule was added. That's how 31 capital B was added. And the long story short of it became that Land Reforms Act, Zamindari Abolition Act, which was placed in ninth schedule, which means immune from judicial review, which means judiciary cannot question the validity of this law, even if it violates fundamental rights. That's how Zamindari Abolition Act was passed. That's how land reforms were implemented in India. But the question still remained. Fundamental rights are inferior. Directive principles, fundamental rights are superior. Directive principles are inferior. Something else happened. What happened? Srimati Indira Gandhi was the prime minister. Srimati Gandhi, she did two things. First, she nationalized the banks. What is bank nationalization? That means some of the private banks were converted into government banks. Why? Madam Gandhi said this is our part of our socialism. Socialism, why? Because when these poor, weaker sections of the society, deprived sections of the society, when they go to these private banks, they ask for loans. These banks, they don't give them loans. They ask for collateral. They ask for documentation. Even after collateral, even after documentation, collateral in the sense, take our gold, but give us loan. Once we repay this loan, you can give us gold back. So use gold as a collateral. Still, loans were not given to the weaker sections of the society. Loans were given to the rich sections of the society, capitalist class, upper sections of the society. Indira Gandhi said, enough is enough. Let's nationalize all these banks. All these banks will be converted into government banks. Matter went to the court. And there was one lawyer who defended these banks which were acquired by the state. And his name is Nani Palkhiwala. And we will discuss Nani Palkhiwala multiple times and later in the Keshavananda Bharti case. One of the terrific lawyers that India has ever seen. Nani Palkhiwala defended these banks and said, don't worry, I will defend you. State cannot do anything. Nani Palkhiwala, along with these banks, approached the Supreme Court. Supreme Court said this bank nationalization is unconstitutional. Why? Madam Gandhi, what are you doing? Sir, we are implementing socialism. What socialism? Sir, Article 39, Clause C. What is that? Operation of economic system should not result in the debt, should not result in the concentration of wealth and means of production to the common detriment. Because this wealth, these banks, they cater to the rich. So it is leading to a situation where wealth is concentrated by these individuals to the detriment of others. This wealth is shared with the upper class, not with the poor. This wealth is used to give loans to the capitalist class, not to the poor. So to implement Article 39B, to implement Article 39C, we are nationalizing the banks. Yes, you can do that. Where is the compensation? Where is the compensation? You have to pay compensation. Sir, where is it mentioned? It's mentioned under Article 31. You have to pay compensation. Madam Gandhi asked her colleagues, what are we doing here? Said, ma'am, we made a mistake. Said, what? We should have placed this law in ninth schedule. So you should have told me before. Sorry, ma'am, but please forgive us. Don't kill us. Said, now what do we do? Ma'am, we can tell the court that we are giving them compensation. The government told the court that we are giving them compensation. Supreme Court said no. Even this compensation is not fair. Because the government said we will give these bank owners compensation in the form of bonds, and these bonds will mature after 10 years. So when Article 31 Talks about acquisition by the state, where the state can acquire a bank, for example, can acquire an estate, for example, can acquire an organization for that matter, but the state has to provide compensation. The government told the Supreme Court, sir, we are giving them compensation. Compensation in the form of bonds, which will mature after 10 years. After 10 years, they can encash these bonds. The Supreme Court said, no, this compensation that you are giving, this compensation cannot be anything. This compensation has to be just, reasonable, fair. These bank owners, you are giving them bonds which will mature after 10 years. This is not a fair compensation. Bank nationalization is unconstitutional. Okay. Another decision was taken by Srimati Indira Gandhi. President issued an order on the advice of the Prime Minister that the rulers of the princely states will no longer be called princes. What are these princes? This is where we come across another important concept, privy purses. There were 562 princely states during the colonial period, during British India. When Indian Independence Act was passed in 1947, 15th of August, these princely states were given options. Either join India or join Pakistan or stay independent. So princely states could have stayed independent as well. Sardar Patel came into the picture, and Sardar Patel tried to convince majority of these princely states that you should come and join hands with India, be part of India. And Sardar Patel convinced most of them. How? Sardar Patel said, all you princes, your bungalows, your havelis will be yours. I said, okay. Your vintage cars will be yours. Okay. The diamonds and pearls will be yours. Okay. On top of that, the government will give you a privy purse. Like pocket money, no questions asked. Wherever you want to spend, you can spend it. What will be the value of this princely purse? Sir, it will depend upon the length and breadth of your territory, your princely state, the revenue that you have been generating. Said, okay, how much would the Nizam of Hyderabad get? Sir, 70 lakhs a year will be your privy purse. Okay. I am the ruler of Kakodia, which is another princely state. How much would I get? Sir, you will get 73 rupees. Why? Because it depends upon the revenue of your princely state. Smaller the princely state, lesser revenue, which means lesser privy purse. Larger the princely state, larger the revenue, more the privy purse. And this is the money which you can use without any restriction, without any question, no questions asked. We will give you this money, and we will mention it in the constitution itself. And based on the assurance given by Sardar Patel, these princes decided to join Union of India, because Sardar Patel said, we will give you everything, but you have to give up just one. What is that? Give up your sovereignty. Don't call yourself sovereign. Merge with the Union of India. Be part of India. And we will give you privy purse as well. Indira Gandhi realized that there are these princes in Jaipur, for example, in Rajasthan, for example. They take money in the form of privy purse from the government of India, and then they use the same money to contest elections against me. How's that possible? For that, what do? Can't amend the constitution like this. So what we can do, President, do one thing. Madam, what? You issue a notification and say, these princes will no longer be princes. These erstwhile rulers of princely states will no longer be princes. When you are not a prince, which means you won't be given a privy purse. These princes approached Nani Palkhiwala. Nani Palkhiwala, please help us. Who are you? I am Madhuraj Scindia. Okay. What is your dispute? I have been stripped of my title. Title in the sense I am not called Maharaja. And ultimately what will happen when I am not a ruler of the erstwhile princely state? Titles are not awarded in any case because Article 18 has prohibited it. But we were deemed to be the princes, erstwhile princes of our princely state. And we were given this privy purse. Indira Gandhi has abolished it. How? She has asked the president to issue an ordinance and stop calling us prince, which means we will no longer get privy purse. Nani Palkhiwala said, okay, I'll take your case. I'll approach the Supreme Court. Nani Palkhiwala won this case. Indira Gandhi said, what do I do? On one hand, I have these princes. On the other hand, there is this brilliant legal luminary, Nani Palkhiwala. What do I do? Indira Gandhi asked her colleagues, legal experts, what do I do? Indira Gandhi was told, Madam, something similar to what your father did in 1951. Said, what? Let's amend the constitution. Okay, what do we mention in that constitution? Madam, let's amend Article 31, add Article 31 capital C to the constitution. What will it mention? If the parliament enacts a law. But why do we want to amend the constitution? Ma'am, the specific problem is with these two directive principles of state policy. This problem you will always encounter because the position of the Supreme Court is directive principles are inferior, fundamental rights are superior. Unless and until we give these two directive principles superiority over fundamental rights, we can't implement the socialist programs that we are trying to implement. So we can't abolish the privy purse, we can't nationalize the banks, we cannot implement some of the land reforms further if we want to implement. And it is important for that we need to go a step further. In 1951, we said any law placed in ninth schedule, there won't be any judicial review. But to be on the safer side, what we need to give primacy, superiority to these two directive principles of state policy. If we do that, then it will make our job easier. I said, okay, let's do that. Article 31 capital C. This was amended to the Constitution in 1971, 25th Constitutional Amendment Act. It says, if the Parliament enacts a law, and this law is to give effect to two directive principles of state policy. Which are these two directive principles? 39B and 39C. Even if this law violates Article 14, 19 and 31, this law cannot be declared unconstitutional. And we will go a step further. This law cannot be challenged before any court of law. There will be no judicial review either. Madam Gandhi said, is this okay? I said, yes. Let's go to the parliament. Parliament, here is a constitutional amendment bill. What sort of bill? This bill, this proposal is that we want to give primacy, we want to give superiority to two directive principles of state policy over three fundamental rights, because there is that judiciary which says directive principles are inferior, fundamental rights are superior. How can we implement socialism if directive principles are declared inferior? We have been placing more emphasis on our rights, but what about our duties? For that, here is my proposal. Let the Parliament of India pass this bill and give primacy, superiority to two directive principles over three fundamental rights. And this temple of India's democracy, this parliament is saying that this law, which is giving effect to directive principles, cannot be challenged in any court of law. There will be no judicial review. And then basis this law, privy purse was abolished. Basis this law, banks were nationalized and courts could do nothing. Even this was challenged in Keshavananda Bharati case 1973. I'll just take 5 more minutes. Be patient. This constitutional amendment, where because of 25th Constitutional Amendment Act 1971, two DPSPs were given superiority over three fundamental rights, this was also challenged. But Supreme Court in Keshavananda Bharti case said this is constitutional. If you want to give effect to two DPSPs, that means you want to make them superior over three fundamental rights, we don't have a problem, please go ahead. Madam Gandhi was happy, but the court said, Madam Gandhi, listen. Said, what? We have a problem with one provision. Said, what is that provision? You are saying there will be no judicial review. That is something that we cannot accept. Because judicial review is part of the basic structure of the Constitution. Yes, you can give shape, you can give effect, you can implement two DPSPs, and in the process, it may violate three fundamental rights, 14, 19, 31. But we will have the power to review. What if it violates other fundamental rights? What if it violates other provisions of the Constitution? Right? So we will have the power of judicial review, but you can do this. I said, okay. 1975, emergency was imposed. Why was emergency imposed? We'll discuss slightly later. And during emergency, a Constitutional Amendment Act was passed known as 42nd Constitutional Amendment Act, which is famously known as the mini revision of the Constitution. That means you can say that Constitution was rewritten in 1976 during emergency. Major changes were made to the Constitution. Lots and lots of changes were made to the Constitution. And that is why we say 42nd Amendment was the mini revision of the Constitution. And in this 42nd Amendment, Indira Gandhi asked the Parliament to do one more thing, one more change. What was that change? Article 31 capital C was amended again. Previously, what was amended? 31C said, if Parliament wants to give effect, Parliament wants to pass a law to give effect to two directive principles, 39B and 39C. And in the process, it violates 14, 19, 31, which means these two DPSPs have superiority, have primacy over three fundamental rights. Parliament in 1976 said, if Parliament wants to give effect to any or all DPSPs, and all DPSPs will have superiority over Article 14, 19, and 31. That means we will not stop at 39B and 39C. If Parliament passes a law to give effect to any DPSP, not only 39B and 39C, any DPSP, or all DPSPs, not only 39B and 39C, all DPSPs, and even all these DPSPs will have superiority over three fundamental rights, 14, 19, 31. This was done by 42nd Amendment Act, 1976. And this was also challenged in the court. 1980, Minerva Mills. Supreme Court said this is unconstitutional. Why? Because balance between DPSP and fundamental right is also part of the basic structure of the Constitution. You're disturbing the balance. You're disturbing the harmony between fundamental rights and directive principles by saying all DPSPs will have primacy over three fundamental rights. No. You will have to go back to your previous position. Only two DPSPs, 39B and 39C, will have superiority over three fundamental rights, 14, 19, 31. Let's recap. Directive principles are not enforceable in a court of law. Nevertheless, they are fundamental for the governance of the country. But if the Parliament wants to pass a law to give effect to these directive principles of state policy, and in the process fundamental rights are violated, what will happen? Are fundamental rights inferior or directive principles inferior? What is the relationship between the two parts of the Constitution? The initial position of the court in Champak Dorarajan case was that directive principles are inferior, fundamental rights are superior. State, you can give effect to DPSPs without violating fundamental rights. Then came the position that two DPSPs, 39B and 39C, they will have superiority over three fundamental rights, 14, 19, 31. Court said this is constitutional, you can go ahead. So for the first time, Keshavananda Bharti case, 1973, for the first time, DPSPs were considered, two DPSPs were considered superior over three fundamental rights. Then the parliament tried to expand it further and say, why only two DPSPs? Why not all DPSPs have superiority over three fundamental rights, 14, 19, 31? The Supreme Court in Minerva Mills case said, no, this is enough. Because if you do that, you're disturbing the harmony, the harmonious relationship, the balance between directive principles and fundamental rights. Only two DPSPs, 39B and 39C, will have superiority over three fundamental rights, 14, 19, 31. But then in 1978, another Constitutional Amendment Act was passed, 44th Constitutional Amendment Act, 1978. What happened because of this amendment? 19(1)(f) was repealed. Article 31 was repealed. Deleted. Article 31A continues. Article 31B continues. Article 31C continues. Article 19(1)(f) and Article 31 was deleted and converted into Article 300 capital A, which is a constitutional right. That means it was deleted from the list of fundamental rights and made other constitutional right under Article 300 capital A. But 31A continues. What is 31A? The state may acquire land, property, estate, and this will not be deemed violative of Article 14, 19, 31. That's 31 capital A. 31 capital B creates 9th schedule. Any law placed in 9th schedule, judiciary cannot question this law. 31C, two DPSPs, 39B and 39C, have superiority over three fundamental rights, 14, 19, 31. But these two fundamental rights were deleted and converted into other constitutional right, 300 capital A. Why? Two reasons. Reason number one, now the state, when it has to acquire property to implement socialism, it does not have to pay compensation. Because fair compensation should be given. That's what the Supreme Court said in bank nationalization case. Now, if we want to implement directive principles of state policy, and for that we violate right to property as a fundamental right, we don't have to pay compensation at all. That is why delete it as a fundamental right and make it other constitutional right. And the minister who introduced this bill to delete right to property as a fundamental right, he said that fundamental rights have some sanctity. Sanctity in the sense they have some credibility. Credibility in the sense they should not be subjected to repeated amendments. If you are subjected to repeated amendments, then it loses its sanctity. Sanctity in the sense, here is Australian cricket team, for example. It was considered to be invincible, a team that you can't defeat, when it was led by legendary Steve Waugh. For maybe I think 16, 17 or 22 tests together, they were not defeated by any cricket team. So they were considered to be invincible. But if after that they are repeatedly defeated, defeated by Zimbabwe, defeated by West Indies, defeated by Namibia, defeated by other countries. Can we call this team invincible? We can't. Similarly, there is some sanctity available to and attached to fundamental rights. If it is repeatedly amended, repeatedly modified, then it loses its sanctity, it loses its charm of a fundamental right. The minister said this right to property has been amended multiple times: 1951, 1955, 1963, 1971, 1973, 1976. So, this right to property as a fundamental right has been subjected to repeated amendments, because of which it has lost its sanctity. So, it is better remove it from the list of fundamental rights and add it as other constitutional right under Article 300 capital A. That's the relationship between DPSP and fundamental rights. If you have any questions, let me know. Then we will take a break. We will come back and discuss remaining portions of directive principles, where we will discuss uniform civil code. Questions, please. It means all DPSPs are superior to fundamental rights. Only 2 DPSPs are superior over 3 fundamental rights. What is ninth schedule? Any law placed in ninth schedule, there won't be a judicial review. Whole topic is so fascinating. Yes, it is. What happened when government offered 10-year bonds? Supreme Court said this is not a fair compensation. So you have to give them compensation now. Can you repeat Minerva Mills case once? Minerva Mills, 1980, Supreme Court said, if you are giving primacy to all DPSPs over 3 fundamental rights, you're disturbing the balance between the 2 parts of the Constitution. Because there is no inherent conflict between DPSPs and fundamental rights. Fundamental rights are for the promotion of political democracy. DPSPs are for the promotion of social and economic democracy. Implement both, so there is no conflict between the 2. But when you disturb the balance by tilting scales in favor of DPSPs and lowering the stakes of fundamental rights, that is something that we will not allow, because this harmonious balance between the 2 parts is also part of the basic structure of the Constitution. Why Patna High Court decision overruled by Supreme Court? Bhavna, I never said it was overruled by the Supreme Court. Patna High Court decision said that Land Reforms Act, Zamindari Abolition Act is unconstitutional. Then Parliament got together, amended the Constitution. Constitution was amended. At last, which one is superior? 39B and 39C. These are the 2 DPSPs superior over 14/1931. Full stop. Can you explain Keshavananda Bharti case? We'll discuss that separately. So after DPSP, we will look at fundamental duties. After fundamental duties, we will look at Keshavananda Bharti case. So possibly tomorrow we'll discuss Keshavananda Bharti. Sir, then any law can be placed in 9th schedule and Parliament can do whatever they want. That's why you should attend the classes on a regular basis. We have discussed previously that any law placed in 9th schedule till 24th April 1973, there won't be judicial review. Laws placed after 1973, there will be judicial review. Why? Because it was in 1973 Keshavananda Bharti case that Supreme Court said judicial review is part of the basic structure. Okay. Is Privy Purse still given? No, it has been abolished. 26th Constitutional Amendment Act abolished Privy Purse. Okay. Let's take a break. We'll meet 8:11 or 8:12, exact 15-minute break. See you on the other side of the break. Shall we start? Okay. Now let's look at Article 44 of the Constitution, which deals with Uniform Civil Code. And you should remember this article number because it is in the news and can be asked in the examination. But one thing, when we looked at that Article 39B and 39C will have superiority over Articles 14, 19, and 31. Now, since Article 31 has been repealed, 31A continues, 31B continues, 31C continues. But since Article 31 has been repealed, so we can say the existing position is, existing relationship between DPSP and fundamental rights is that there are two DPSPs, 39B and 39C, which are superior, which have primacy over two fundamental rights, 14 and 19, since Article 31 has been deleted. But sir, Article 19 also has been deleted? No. Article 19(1)(f) has been deleted. Article 19(1)(a), freedom of speech and expression, continues. Article 19(1)(b), right of assembly, continues. Article 19(1)(c), right to form union, association, cooperative society, that continues. So Article 19 continues. 19(1)(f) has been repealed, but 31 has been removed. 31A continues, B continues, C continues. Done? But 31A is a different article. 31B is a different article. 31C is a different article. 19(1)(a) is part of Article 19. 19(1)(f) is part of Article 19. That is why we say 19 has 39B and 39C has primacy over 14 and 19. When was Article 31 deleted? 1978, my dear. 44th Constitutional Amendment Act. Okay. Now, what is this Uniform Civil Code? Let's say, for example, we have criminal laws. Now, the first question that you can ask me, sir, what is a criminal law? In a criminal law, there are two parties to a dispute. One, an individual or an organization, and the other side is the state. In a civil dispute is a matter between you and me, between two private individuals. State is not involved. So there is a violation of contract by you or me. It's a civil dispute. In civil dispute, it's a dispute between two individuals or two parties or two organizations. State is not involved. But in a criminal case, the other party is the state. For example, sir, murder is between two individuals. You killed me. So why is the state involved in a criminal case? Rape between two individuals. Why is state involved? Because state is involved because state has the duty and the responsibility to ensure peace, tranquility in the society, public order in the society. Murder violates public order. That's why state has to come into the picture. Rape violates public order. That's why the state has to come into the picture. So in a criminal case, the other party, because there is a dispute, the other party is the state. All criminal cases are applicable to every single individual, no discrimination. On the grounds of religion. That means if there is a murder case, dacoity case, terrorism case, rape case, SC/ST atrocities case, It doesn't matter what is the religion of a particular individual. Regardless of your religion, you will be booked under these laws. You will be booked under these cases. So there is no discrimination on the grounds of religion. Criminal laws are common for all the religious communities. Even civil laws are common and no discrimination on the grounds of religion. Whether you have violated a contract, whether there is a dispute between you and me on the piece of property, doesn't matter what your religion is, the law is same, common for all, equality before law. But then there are some laws which are known as personal laws. Criminal laws are common for everybody, regardless of religion. Civil laws are common for all, no discrimination on the grounds of religion. But then there are personal laws. Which are these personal laws? Related to marriage, related to divorce, related to adoption, related to inheritance. This is where different religious groups are governed differently. For example, Muslims are governed under the Muslim personal law. Hindus are governed under the Hindu laws. Parsis are governed by the Parsi laws. Christians are governed by their own laws. And Hindus include Buddhists, Jains, and Sikhs as well, under the definition of the personal laws. So when it comes to personal laws, we see that there is a different set of jurisprudence altogether. In a sense, Muslims are governed by their own Muslim personal law based on religion, based on their marriage, divorce, inheritance, adoption. Hindus governed separately, Christians governed separately, Parsis governed separately. Hindus include Buddhists, Jains, and Sikhs as well. But why is that the case? Look at the revolt of 1857. What was the immediate trigger of the revolt of 1857? Those on-field rifles, where if you have to inject cartridge into this Enfield rifle, you had to bit this cartridge. And this was made up of, allegedly, cow fat and pig fat. Cow affects the sensibilities of Hindus. Pig affects the sensibilities of Muslims. That is how Indians were enraged, and that is what is considered to be the first trigger or immediate cause of the revolt of 1857. Prior to that, British tried a lot to reform Indian society. That is what they called white man's burden. So British thought that civilizationally we are superior than these Indians. And it is a burden on us. It is a burden on the white man to civilize these brown people, uncivilized people. And they were looking at our religions with disdain. What are these Hindu laws? What do they do? No intercaste marriage? What rubbish? What is this parda system? Why are you marrying multiple wives at the same time? So British, and why are widows not allowed to remarry? Why is somebody, if you are a woman and you have lost your husband, you also have to die, lie down on the pyre of fire and kill yourself? Sati, the practice of sati. So British tried a lot to reform the laws related to various religious communities. Sati was abolished, widows were allowed to remarry, intercaste marriages were allowed, so on and so forth. But then soon after revolt of 1857, British realized that what was the immediate cause of revolt of 1857? Religious sensibilities. Now, if we want to govern India for a long time, do one thing. Don't interfere with their religion. Because these Indians are very touchy about their religion. You kill them, you violate their freedom of speech and expression, you violate their dignity, you snatch their jobs, you snatch their property, they will not raise a finger. But the moment you touch their religious sensibilities, they will kill you. So these are too touchy about their religion. So we will not touch their religion. Muslims, you are governed by your own personal laws. We will not interfere. Hindus, you are governed by your own laws. We will not interfere. Parsis, own Christians, bye bye. You will be governed by your own laws. We will not interfere. But when constitution was being drafted, the makers of the constitution said that we should not have these separate personal laws for different religious communities. We should have a uniform civil code. Just like criminal laws are common for everybody, civil laws are common for everybody, personal laws should also be common for everybody. So that it doesn't matter what your religion is, laws related to marriage will be common for everybody. Laws related to divorce will be common for everybody. Laws related to inheritance will be common for everybody. Laws related to adoption, when you want to adopt a child, will be common for everybody. That means in personal matters, there should be a uniform civil code. But then it was placed under directive principles of state policy. Why? Not because DPSPs are inferior, not because DPSPs are so inferior that they don't deserve to be implemented. DPSPs were given not legal enforceability, they were not made justiciable because state needed time to implement them. Time in the sense, we have just come out of partition, which has partitioned this country into two, India and Pakistan. And the reason for partition is religion. Now, if religion is the reason for our partition, now after the independence, we have to give all the religious communities a sense that India is not against their religion. India is not there to trample their religion. India is not there to enforce one religious sensibility over all the other religious communities. Because Pakistan may have been created in the name of religion. India was not created in the name of religion. India remained secular. Pakistan became an Islamic state of Pakistan, but India remained secular. So we need time to implement uniform civil code, because if religion is the reason for partition of this country, and immediately after the partition, immediately after the commencement of the constitution, if we dissolve all these religious personal laws and implement a uniform civil code, maybe the minorities will feel that they are left out. Maybe the minorities will feel they are discriminated. Maybe the minorities will feel that we should have also left Pakistan, or we should have created a separate country. So we will not implement uniform civil code. That doesn't mean we will never implement a uniform civil code. It's just that we need time so that we can persuade these religious communities that you should do away with your personal laws and have a uniform civil code. Pandit Nehru and Dr. Ambedkar, who was then the law minister, they said we will take first step towards uniform civil code. And what is the first step that we will take? We will codify the Hindu laws. We will start with the Hindu religion. Once Hindu religion has been reformed, then we will shift to Islam, Parsis, Christians, Jews, and others. And then we can implement a uniform civil code. Because previously, intercaste marriages were not recognized in Hinduism according to then existing laws. A girl child was not given right to inheritance. A girl child or a woman or a wife was not given the right to divorce, right to grant divorce. So Dr. Ambedkar and Pandit Nehru together, they decided that let's first modify and codify all the Hindu religious laws so that we can have one law, we can have one broad law which will talk about multiple facets of the personal laws related to Hindus. So we will have a Hindu Marriage Act, we will have a Hindu Succession Act which deals with inheritance. So we will have different laws for Hindus, and these laws will be non-discriminatory. No discrimination on the grounds of caste, no discrimination on the ground of gender. And once we have touched the Hindu laws, then we will jump to other religious communities, and then this idea of uniform civil code would be implemented. And that is how 3 Hindu code bills were passed. 3 Hindu code bills, that means codify all the Hindu laws related to marriage, related to divorce, related to inheritance, related to adoption. These 3 bills were passed and Hindu laws were reformed. But then other religious communities were not touched. And this continued till we reached Shah Bano. Shah Bano was 60 or 70 years old, an old woman. She was not earning, she had no means of livelihood. She was married to an advocate of Madhya Pradesh High Court. And the Madhya Pradesh High Court, her husband divorced her and he married a younger woman. Why? Because in Islam, a husband can have multiple wives as well. That is not the case in Hindus. That's not the case in other religious communities. But since Muslims are governed by their own laws, where a husband can have at the same time four wives, this individual divorced her, divorced his wife without taking her as a wife, divorced her and married someone else. Because under other laws, Hindu laws, if your wife is allowed alive, you cannot marry the second time. If your wife is dead, then you can marry. But Shah Bano was alive. But since she was a Muslim, Muslims are governed by their own Muslim personal laws. The husband divorced her and married someone else, a younger woman. Shah Bano approached the Madhya Pradesh High Court. My lord, I have a dispute. Said, what? I am a Muslim. Said, okay, that is, your name is evident, Shah Bano. I was married to a man. Said, okay, he divorced me. Okay. But do you know what he did? Said, what? He gave me maintenance for 3 months. That means he gave me money to maintain myself, to support myself, but only for 3 months. Where will I go after 3 months? What will I eat? I have no means of livelihood. I am old as well. I said, but why are you here? Why are you discriminating me against a Hindu woman? If a Hindu woman is divorced by her husband, she gets maintenance for her entire life. But I, as a Muslim woman, I get maintenance only for 3 months. Is this not discrimination in a secular country such as India? Madhya Pradesh High Court said, yes, you are right. Shah Bano's husband, come here. You're also an advocate here, so you should know. Give her maintenance for her entire life. That's our directive. Said, sir, you can't do that. Why? We are governed by our own Muslim personal laws. Under Islam, I can pay maintenance to my wife, who is now ex-wife, only for 3 months. After that, she's not my wife, so why should I support her? I will not do that because that is not under my personal laws. This case was filed as an appeal before the Supreme Court because now the Shah Bano's ex-husband approached the Supreme Court. My lord, we are governed by our own Muslim personal law, under which I have to pay maintenance to my wife, ex-wife, only for 3 months. Madhya Pradesh High Court said, pay compensation for your entire life. That is discriminatory. That violates my personal laws. Please help me. The Supreme Court said, we can't help you. You have to pay maintenance to your wife, ex-wife, for her entire life, not for 3 months, as is mandated by your religion. Because this is not gender justice. Then there were people from the Muslim community, the mullahs, those who are the leaders, self-proclaimed leaders of the Muslim community. They cried, Islam is in danger. In this country, India, our laws are not of any value. What will we do? Where will we go? We are not allowed to practice our religion. If our religion says that you have to pay maintenance only for the 3 months, who is the Supreme Court to order that you pay maintenance for the entire life? This is discriminatory. We will not allow protests, demonstrations, blah, blah, blah. And ultimately, these Muslim leaders, or so-called Muslim leaders, clerics, mullahs, approach very good-looking, suave gentleman, Rajiv Gandhi. And Rajiv Gandhi then was the prime minister. Rajiv Gandhi was persuaded that you have to undo this judgment given by the court in Shah Bano. Because in Shah Bano judgment, the Supreme Court said, we regret that even after so many decades, we are in 1980s, even after so many decades of India's independence, more than 3.5 decades after India's constitution was enacted, we still have not implemented Uniform Civil Code. If this Uniform Civil Code was implemented, then Hindu woman, Christian woman, Sikh woman, Parsi woman, Muslim woman, all would have the same rights under this law. But since it's a directive principle of state policy, we cannot direct the parliament to implement this. We cannot direct the government to implement this because these are not enforceable in a court of law. But we regret that even after so many decades, we have failed to pass a uniform civil code. If it was a uniform civil code, then this problem would not have arisen. Rajiv Gandhi was persuaded. Rajiv Gandhi had a brute majority in Lok Sabha. More than 400 MPs out of 543 belonged to the Congress party, because Rajiv Gandhi won the election in 1984, riding on the sympathy wave because her mother was assassinated. And the parliament passed a law. Ironically, it was named as Muslim Women Protection of Rights on Divorce Act 1986. And this law basically said that the husband has to pay compensation to his wife, maintenance to his wife, only for 3 months. Compensation was increased, maintenance amount was increased, but this maintenance amount can be paid only for 3 months as mandated by the Muslim personal law. To satisfy a particular vote bank, Rajiv Gandhi decided to undo a beautiful Supreme Court judgment of 1985, Shah Bano judgment, and passed a law to undo this verdict and said that a husband has to pay maintenance to his wife only for 3 months, although the maintenance amount will be increased, but you cannot be forced to pay maintenance for the entire life. When Rajiv Gandhi was persuaded from doing this, basically taking into account Muslim vote bank, let's be clear about that. There is no ifs and buts. This is the agenda. This is the objective. He started pandering to the Hindu interests as well, so as not to get a sense that this government is only catering to the Muslim sensibilities, and what about Hindu sensibilities? That is why if you look at the statements of Dr. Subramaniam Swamy, he would tell you that the real individual who is responsible for the construction of the mega Ram temple at Ayodhya is not Mr. Modi, is not the Supreme Court, is Rajiv Gandhi. Why Rajiv Gandhi? That dispute on who owns this land where Babri Masjid was erected, there was a dispute. There was Babri Masjid there. And then the locks of the Babri Masjid were closed. It was kept under lock. Nobody could enter. And the Hindu side was allowed to pray at the Ram Chabutra, which was outside of the Babri Masjid, in the vicinity of the Babri Masjid area. There was a makeshift Ram temple, Ram Chabutra, where Hindus could also pray. But then there was a dispute. There were riots in 1949, and ultimately the gates of the Ram temple, this makeshift Ram Chabutra, was also closed. So nobody could have paid obeisance to Ram Chabutra. And in 1986, a local court in Allahabad ordered that this lock should be opened so that Hindus are allowed to pray at Ram Chabutra. And it is argued that it was done on the directions of Rajiv Gandhi. Because on one hand, you pandered to the interests of the Muslims by undoing the judgment of the Supreme Court in Shah Bano case. On the other side, you also want to appear pleasing before the Hindu community. You are allowing them to enter and pray at the makeshift Ram temple, Ram Chabutra in Ayodhya. So you are satisfying both the interests. But ultimately, a brilliant, gender justice oriented judgment of the Supreme Court was nullified by the parliament in 1986. And the question was Uniform Civil Code. Should Uniform Civil Code have been implemented or not? Then one lawyer who was representing Shah Bano, in this case, Daniel Latifi, he also challenged the validity of this Muslim Women Protection of Rights Act on Divorce Act 1986, challenging how can Parliament undo the law, undo the judgment given by the Honorable Supreme Court. If the court said provide maintenance for your life, why is Parliament saying provide maintenance only for 3 months? But Supreme Court upheld this law, Supreme Court said this law is okay because Muslims are governed by their own personal laws. Yes, the maintenance amount can be enhanced, but till the time there is uniform civil code, Muslims will be governed by their own personal laws, as would the Christians, as would the Parsis, as would other members of the community. And now the question is, should uniform civil code be implemented or should it not be implemented? There are arguments in favor and then there are arguments against a uniform civil code. Why should uniform civil code be implemented? Number one, to implement Article 44, which is a directive principle of state policy, which Article 31 says shall be the duty of the state to implement, because implementing directive principle is fundamental for the governance of the country. So for the sake of the constitution, implement uniform civil code. That's number one. Number two, to basically safeguard secularism. In simple terms, what is secularism? Non-discrimination on the grounds of religion. Hindus governed by their own religion, by their own laws, Christians by their own laws, Parsis by their own laws, Muslims under their own laws. So there is discrimination on the grounds of religion. But that is not secularism. Secularism means that law should treat everybody equally. So for the sake of secularism, implement uniform civil code. That is how we can create a real secular India where there is no discrimination on the grounds of religion. Third, implement uniform civil code for gender justice. Gender justice in the sense, even today, a Muslim woman cannot divorce her husband, but a Hindu woman can, but a Sikh woman can. Similarly, a Buddhist woman can. So this is not in aligned with the idea of gender justice, where a personal law of a particular community can violate the rights related to the woman. Why? Because that is what we call constitutional morality. What is morality? What is moral to you may be immoral to me and vice versa. There is a particular thing in a particular religion that is moral for that religion. For example, recent example, where there are Dawoodi Bohras. Dawoodi Bohra, we have discussed yesterday. It's a sect in Shia Islam, and they have their own leader, and their leader is known as Sayyidina. Their own leader has the right to excommunicate its members. So if there are Dawoodi Bohras, all of them, they have a leader. This leader has the right, power to excommunicate one member. That means throw one member out of the Dawoodi Bohra fold. Supreme Court has said this is right. Yes, the leader of that group, you have the right to excommunicate your member. That means unless and until this leader has the right to excommunicate that member, how can you ensure order in your religious group? How can you ensure discipline in your group? What if there is a member who is violating the rules and norms of your religion, norms of your sect? You cannot allow that individual to continue in your fold. You have to excommunicate them. Just like there is a political party. There is a political party and there are members of a political party. For example, JDU is a political party led by Nitish Kumar. But they have a member, Mr. Kushwaha, who is now protesting against the leadership, criticizing the leadership. Maybe he is trying to break the political party. What will Nitish Kumar do to Mr. Kushwaha? Throw him out? Excommunicate him? Remove him? Similarly, a religious group should also have the right to excommunicate some of its members who are revolting against the group, who are violating the rules and the norms of this group. That is moral for that religious community. But we don't have to look at morality of that religion, morality of that group, morality of that identity. We have to look at what is the constitutional morality. Constitutional morality of liberty, equality, dignity of an individual. If you excommunicate that member, which means this member who has been thrown out of that group, he cannot use the religious places of worship of that community. Maybe he will be boycotted by other members of the community as well. Will it not affect this dignity of this individual? It will. So should it be allowed? No. Why? Because forget about your morality. What we have to look at constitutional morality. So forget about whether your religion is allowing you to marry multiple times. Forget about whether your religion is not giving you the right to divorce your husband. Forget about your religion. If your religion is not allowing you to marry the person of other caste, forget about your religion. If this religion is not allowing you to marry the person of the same gotra, because there are people in Haryana where you cannot marry in the same gotra. That is moral to them. But do we have to look at their morality, or do we have to look at the constitutional morality? Constitutional morality dictates that we should have uniform civil code in India, so that there is no discrimination on the grounds of gender. Property rights, for example. For a long time, Hindu women were not given right to property, right to inherit the property of her father, of her parents, of her family. That right was given to the male child. But then the Hindu code laws were passed, and this right was also given to a Hindu woman. But now there are other religious communities where the girl child still does not have the equal right to inherit the property, because more property can be inherited by the man. Is this not gender violation? Is this not violation of the gender justice? So to have justice and implementing constitutional morality when it leads to marriage, divorce, inheritance, adoption, that is why we need a uniform civil code. And it is high time that since 1950, when the Constitution was enacted, and we are in 2023, it has not been implemented yet. DPSP, which relates to Article 44, which relates to Uniform Civil Code, has not been implemented. It is high time. For these reasons, Uniform Civil Code should be implemented. But then there are others who say that we have some arguments against Uniform Civil Code. What are their arguments? Their argument is, number one, and listen to me carefully. They say Constitution talks about Uniform Civil Code and not Common Civil Code. What is the difference between the two? They say if it is a common civil code, that means there will be a common law. Just like common criminal law, common civil law, there will be a common personal law. And this common personal law will be common to all the religious communities. Hindus, Christians, Sikhs, Buddhists, Jains, Parsis, Muslims, everybody, this common law. But that is not what Constitution says under Article 44. Constitution does not talk about common civil code, it talks about uniform civil code. Deliberately, this term uniform has been used, not common civil code. Then what is the difference between the two? Uniform civil code means that there can be one law for the entire Hindu community. But for this entire Hindu community, the law should be uniformly applicable. That means without any discrimination on the grounds of caste, without any discrimination on the place of birth, without any discrimination on the grounds of sex. This law should be uniformly applicable to the entire Hindu community. Similarly, there should be a uniform law applicable to the separate law, uniformly applicable to the Muslims, regardless of their discrimination on the grounds of gender or place of birth or sect or caste, doesn't matter. Whether you agree with this argument or disagree, but that is an argument. The argument is that constitution does not talk about common civil code, it talks about uniform civil code. That means we can have different laws for different religious communities, but then these different laws should be uniformly applicable to all the sections of that particular religion. They say we have another argument. Sir, what is the argument? We have Article 25 of the Constitution, which is a fundamental right. And what is that fundamental right? Freedom to profess, practice, and propagate your religion. I want to practice my religion. If my religion tells me that you can have multiple wives, how can Uniform Civil Code violate Article 25? Because DPSPs are not superior than fundamental rights. Only two DPSPs, 39B and 39C, they have superiority over Article 14 and 19. Article 25 cannot be violated by a DPSP. So if you are enacting a Uniform Civil Code, but you are violating my Article 25, which is the right to practice my religion. If my religion tells me that a wife cannot grant divorce to her husband, how can Uniform Civil Code, which is there to implement DPSP, can violate fundamental right under Article 25 of the Constitution? That's the challenge. That is why we say we can't have Uniform Civil Code. They say forget about Article 25, look at Article 29 of the Constitution. Article 29, every section of the citizens residing anywhere within the territory of India, you have the fundamental right to preserve your culture. And what is that culture? If there is Uniform Civil Code, where we can say that one law should be applicable to all the religious communities. Clear? One law. That means laws related to marriage and divorce will be the same for the entire set of Indians? Yes. Go to the tribal area. There they have marriage by capture. So there is a man riding a horse, capturing a woman, kidnapping her, and then marrying her. Will this be allowed? No. There is marriage by intrusion. The girl likes a boy, packs her belongings, runs to the family of the boy, stays there, intrudes into her family, convinces him to marry, then gets married. Will this be allowed? No. Divorce in some tribal cultures. How do they divorce? They don't have to give notice that I'm giving you the notice for 6 months, we will have to stay together. After 6 months, the court will decide whether you can stay together or not. So this is a cumbersome process. They just take a leaf, split it in the middle, give half to girl, half keeps to himself. That's how the divorce is formalized. Will this be allowed if Uniform Civil Code is implemented? No. But this is a tribal culture protected under Article 29. So when Article 29 talks about the fundamental right to preserve your culture, how can a DPSP under Article 44 violate the tribal culture under Article 29? Not possible. And perhaps that is the reason why the Law Commission of India is not in favor. Because Law Commission of India is a body which is periodically created, set up to look at, to review the laws, existing laws, recommend some of the laws should be deleted or new laws can be added. That's why we have Law Commission of India. So these are people who have the legal knowledge. So they will not say anything off the cuff. They will not say anything which is illegal. Law Commission of India says we are not in favor. Why? Perhaps because of these reasons. Perhaps because the Constitution says it is uniform and not common civil code. Perhaps because of the difficulties of Article 25. Perhaps because of the difficulties of Article 29. That's why they say it is desirable to have a discussion on Uniform Civil Code, but it is not desirable to implement Uniform Civil Code. Then what do we do? Even if we can't implement Uniform Civil Code, even if we can't, even then what we have to do, we have to take into account constitutional morality, and we have to take into account gender justice. without looking at implementing in one go uniform civil code, because uniform civil code can only be implemented if there is a consensus in the society, which appears very difficult to achieve and arrive at. So there is no way without consensus that we can implement uniform civil code, because if there is no consensus, then there will be protests, demonstrations, riots, so on and so forth. There will be law and order problems in India. So if through consensus we cannot, then what can we do? Look at these individual laws, whether related to Hindus, Christians, Jains, Buddhists, Parsis, Muslims, and identify the loopholes in these laws which violate constitutional morality, which violate gender justice, and try to reform them. For example, instant triple talaq. Approach to court. Court did not say that unless and until we have a uniform civil code, we can't set aside instant triple talaq. Court did it. Looking at constitutional morality, not looking at the morality of a particular religion. Similarly, now the Muslim Waqf Board, All India Muslim Personal Law Board, they have approached the court. They have said we will allow women to pray at the mosque and the dargahs as well, but we will have a separate place for them. That means steps are being taken. Steps are being taken to ensure that there is some element of gender justice. And that is precisely what we need to do. Identify individual laws, identify those areas where we see blatant violation of gender justice or violation of constitutional morality, and one by one try to change them without going one single block, without going in one go and implementing uniform civil code. That's the solution to this problem, and that is uniform civil code. Any questions as of now? Okay. Then there are people who say in India that if uniform civil code is there in Goa, can't we have a similar uniform civil code in the rest of the country? Is there uniform civil code anywhere in India? Yes. Where? In Goa. How? Goa was a Portuguese colony. It was the colony of Portugal. And when it was to be acquired by India, when India was to acquire Goa, there was an agreement that all the customs that are prevalent in Goa right now, which means these Portuguese customs, those should continue after acquisition as well. After Goa becomes part of India as well. The government of India said, okay, that means Muslim personal law will not apply in Goa. Hindu code bills will not apply in Goa. The laws related to Christians in the rest of the country will not apply to Goa. Goa will have its own code, and that code is uniform. That means in Goa, laws related to marriage, divorce, inheritance, adoption, there is no discrimination on the grounds of religion. The law is equally applicable to all the religious communities. So if Goa can have a uniform civil code, why can't we have a similar uniform civil code in the rest of the country? That's what former Chief Justice of India, Justice Sharad Arvind Bobde, S.A. Bobde said. He was speaking to some members of the Bombay High Court, and he said, look at, I was serving in Goa, and in Goa they have a uniform civil code. Maybe that civil code we will have to follow and practice in the rest of the country. What is so good about this uniform civil code in Goa? And what is so bad about this uniform civil code in Goa? Let's discuss, because that can be asked in your mains examination. Should Goan model of uniform civil code be implemented in the rest of the country? And by looking at this Goa model of uniform civil code, we come to realize something else. Although it is common for all, uniform for all, but it may also mean uniformity in discrimination. That you can have discriminatory provisions applicable across religions uniformly. When we say uniform civil code, what is our idea? That this law will be very beautiful law. and will be applicable to all the communities, regardless of their religion. No discrimination. But what if this law itself is discriminatory? That means the same discrimination will be applicable to all the religious communities. That is what critics say of Goan model of uniform civil code. It may also mean that you may have discrimination uniformly applicable to all the religious communities. How? Let's take the example. Procedure for registration of marriage. No matter who you are, Hindu, Muslim, Christian, Sikh, Jain, Buddhist, Parsi, doesn't matter. No matter who you are, if you have to register for a marriage, 2 signatures are required. 2 signatures are required. Signature number 1 at the time of intent. Signature number 2 when you solemnize this marriage. No matter who you are, 2 signatures are required. So a Hindu couple, a Muslim couple, a Christian couple, no matter which couple, you go to Goa, you want to marry, those which are part of Goa, those who are the residents of Goa, they will marry under the Goan law. So there they will have to give 2 signatures, 2 times. First, at the time of the intention. Now we have made our intention clear. I'll marry you. Will you marry me? Yes. So let's sign this document. This is our intention that we want to get married. After some time, we'll have to solemnize this marriage. That means we'll have to go to the office of the marriage officer. And there we will solemnize this marriage. Once the second signature is taken, we are husband and the wife. Problem solved. But for Christians, it is different. Specifically for Catholics, it is different. Different in the sense, Catholic couple, husband and the boy and the girl, it's our intention to get married. We will go, we will sign this document. Our intention is clear that we want to get married. But where will we marry? We will marry in a church. And if you're marrying in a church, second signature is not required. Which means somebody marrying in a church, we assume that second signature is taken, which means you don't have to write another time, give another signature for the second time, which means it is like the church entering into a memorandum of understanding with a secular state that any marriage which is solemnized at the church, second signature is not required. That means for Catholics, it is different. For every other religious community, it is different, which means discrimination may be applicable uniformly to all other religions except Christians, except Catholics. And that is what perhaps the critics to Uniform Civil Code say. They say, okay, let's agree. Let's accept that we can have a Uniform Civil Code. But this code will be based on what religion? Laws related to marriage, divorce, inheritance, adoption will be derived from which religion? Is it that you are saying this Muslim law will be applicable to all the religious communities in India? Or this Christian law will be uniformly applicable to all the citizens of India? Or this Hindu law will be applicable to all the religious communities in India? What is this law? That we will have to debate. Because if this law is biased in favor of one particular religion, that means for all other religions, you are discriminating. That's what is happening in Goa. Laws are common for everybody, 2 signatures. But you are from Catholics, then no second signature is required. Why? Because you have solemnized this marriage at church. Something else. Same rules for divorce. Same rules for everybody. It's not like that Muslim husband can say talak, 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 and the divorce will take place. No. Same rules for everybody. Hindus, Christians, Buddhists, Jains, Parsis. Rules for divorce, same. But the marriage which is solemnized at church, which means for Catholics, and all Catholics, they marry at church, they have a different ground for divorce. And what is that ground? Non-consummation of marriage. What does that mean? Husband and the wife, belonging to any religion, you want to divorce each other? Yes, you can. What are the grounds? Irretrievable differences between the two. We can't live together. I hate her. She hates me. We can't live together. Okay, divorce. Same rules for everybody. Same rule that husband is not able to bear child or woman is not able to bear child. And now 5 years are over. It's not possible. So divorce. Husband is impotent. Wife has an issue. Divorce. Common for everybody. No issues. But if this marriage is solemnized at church, they have one extra ground for divorce: non consummation of marriage. What is non consummation of marriage? If the marriage has taken place, but the husband and wife, they have not indulged in sex, they have not had in sexual intercourse, that means marriage has not been consumed. This non consummation of marriage is a ground for divorce, but only for those who have married at church, where the marriage has been solemnized at church. This is not a ground for someone else. This is not a ground for others. That means for others, discrimination, uniform discrimination. Another point: the beautiful argument in favor of Goa model of uniform civil code is regime of communion of assets. What does that mean? This is boy and this is girl. Done. Boy has inherited some property. Girl also has inherited some property. Clear? Now they get married. They're a couple. And over a period of time, they have to seek divorce as well. That means whatever property they have, it also needs to be split. Clear? In Muslims, it is different. In Hindus, it is different. That means different communities are governed differently under the personal laws in India. But in Goa, it is different. What is different? All the property inherited by the boy, all the property inherited by the girl, and then the property which is acquired by boy after the marriage, and the property acquired by the girl after the marriage, all of this is put together. And at the time of the divorce, it is split into two. Which means otherwise, in other parts of the country, woman would get nothing. She gets peanuts. She gets nothing. She doesn't get the property on which the boy has inherited some property. No, she doesn't. But in Goa, they do get this access. But then what they also do in Goa, boy and a girl, they come into an agreement that we do one thing. Whatever property you have inherited, you become the owner of that property. Don't give it to me. Don't share it with me. Whatever property I have inherited, I will keep it with myself. We will not share this property with us. After our marriage, whatever property we acquire, that will be part of communion of assets. They can do this as well, but uniformly throughout. But then there is discrimination against women. What sort of discrimination? Although on paper, all these assets are owned jointly by boy as well as girl, by husband as well as wife. It says the manager of this property is the husband. Owner is both, husband as well as wife. But who is the manager of these assets? Husband. And there are people, there are women in Goa protesting today. They say, we don't know. On this property, our husbands have taken loans and we are not aware of that property. We are not aware of that loans. Maybe this husband, they have spent this money in a casino in Goa and we are completely unaware. Sometimes what is happening? This asset, which can be a flat, this flat is given out as rent by the manager of this property, who is the husband, and this rent is taken by the husband, not shared with the wife. That means uniformly, you are owner of this property together, communion of assets. But who is the manager of this property? Husband. Uniform discrimination against women. That is why we say, even if Goa has a uniform civil code, but that doesn't mean it is based on justice. It may also mean that this discrimination is uniformly made applicable to all the religious communities. That's the Goa model of uniform civil code. But sir, you said there is problem with uniform civil code. Sir, you said there is problem with Goa model of uniform civil code as well. Then what is the solution? The solution is Special Marriage Act. Sir, what is the Special Marriage Act? It was passed in 1954. Sir, what was the purpose to pass this law? Let's go back to British. When British realized that Indians are too touchy about their religion, we should not interfere in their religious matters. The question arose on interreligious marriages. British, you are liberal, you are intellectual. There is this white man's burden on you. Now, there is a boy and a girl belonging to different religious communities. Give us the opportunity that we want to marry. So the boy is Muslim, girl is Hindu. Love jihad. We will not interfere. Boy is Hindu, girl is Muslim. Oh my God. Hindus will kill us, Muslims will kill us. No, we will not interfere. But sir, how do we marry? You renounce your religion. Sir, you say, I come out of Islam, I come out of Hinduism, which means now for us, you are neither Hindus nor Muslims. We will allow you to marry. That means during the pre-independent India, during the colonial period, if inter-religious marriage was to be consumed, there was a requirement. The requirement was you give up your religion. You give up your religion, then you can marry. Because we cannot affect the sensibilities and touch the sensibilities and violate the sensibilities of your religious leaders. They will kill us, they will lynch us. After India got independence, after constitution was enacted, and we don't even have a uniform civil code, then policymakers thought, what do we do? How should we allow intercaste marriages, interreligious marriages, without any need to convert, without any need to give up your religion? What do we do? And for that, a law was passed known as Special Marriage Act, where if a couple belonging to different religions, they want to marry each other, they don't have to give up their religion. They don't have to convert into each other's religion and then marry. Without conversion, they can get married. And if one partner is Muslim, the other partner is Hindu, that doesn't mean through triple talaq you can divorce. That doesn't mean women will not have the right to divorce. You will have the right to divorce. You will have the right to come out of this marriage. That is what we call Special Marriage Act, which is basically a secular law which deals with marriage, which deals with divorce as well, without any discrimination on the grounds of sex, without any discrimination on the grounds of religion. So that Special Marriage Act should be strengthened. And if that Special Marriage Act is strengthened, then personal laws are immaterial. Allow people, create an awareness so that more and more Indians, regardless of their religion, instead of marrying under their personal laws, they marry under the Special Marriage Act. When they marry under the Special Marriage Act, that means personal laws are not valid. So your marriage, your divorce, your inheritance, your adoption will be based on one secular law, not based on your personal laws. But this law, which was meant to facilitate interreligious marriages, it is creating huge hurdles instead. Why? Some journalists in India, one such journalist, for example, you don't have to cite these names in the exam. This is just to make you understand. Suhasini Haider. She's the daughter of Dr. Subramaniam Swamy, but married to a Muslim. The father-in-law was Salman Haider, who was previously the Foreign Secretary of India. She also commented on this law and said it is easy today to convert your religion rather than get married under the Special Marriage Act, because this Marriage Act is basically creating more problems than solutions. Why? What are the problems? Problem number one. Legally, India has a clear route to interreligious marriage, and that is what we call Special Marriage Act 1954, under which a couple, no matter what their caste or religious background is, they can marry without any need for conversion. But what is the problem with this law? Number one, notice period. What is the notice period? A Hindu has to marry a Hindu. They can decide today, and in 5 minutes, they can marry. Muslim and a Muslim, they have to marry. If they meet now and they fell in love at first sight, all they have to say, Kubul hai, Kubul hai, Kubul hai, marriage. But if it is Hindu and Muslim, people belonging to different religious groups, notice period. If you have to go and approach and ask for marriage under Special Marriage Act, you are Hindu, you are Muslim. Okay. Give us a notice. 1 month. After 1 month, come back and we will solemnize your marriage. This notice period of 1 month, why is it given? Intention was novel, intention was good. What was the intention? Here is boy, here is girl. The boy is in the city, the girl is in the city. But the boy comes from a village. And in the village, boy already has a wife. Now in the city, the boy says, I am a bachelor. Please marry me. I said, okay. But if it is 1 month notice, that means the marriage officer where you go to register this marriage, he will put out a notice. Anybody having any objection with this marriage, please come to us within 1 month. After that, these two will marry. Somebody from the girl's family may see this notice. Somebody from the boy's family will see this notice and say, what are you doing? You're already married. They will rush to the marriage officer, stop this marriage. This guy is already married. So this was a very good intention behind this notice period. But this notice period has been violated. Why? If the boy is from one religion, the girl is from another religion, both these religious communities will attack each other. You have snatched our daughter, you have snatched our daughter, you have snatched our boy, you have snatched another boy, as if these are your personal property. And now what will happen? People will come to know what is the exact location of this marriage, what is the exact date of this marriage. And now these religious groups will come together, the Ovaisis, the Bajrang Dals and Vishwa Hindu Parishad, they will come and they will stop this marriage. How can you marry a non-Hindu? How can you marry a non-Muslim? So the fundamental right to marry the person of your choice is getting violated because of this notice period. That's number one. Number two, Act stipulates something different. Act talks about something different and something very, very difficult. Difficult in the sense, the boy is from Karnataka, for example. The girl is from Maharashtra. Let's say there is a dispute on Belagavi between Karnataka and Maharashtra. Now, Kannadigas and Marathis, they have tussle with each other. And suddenly, in this tussle, like a Shakespearean play, a beautiful couple, they also get embroiled in this. The girl says, if I tell my family that you are from Karnataka, they will not allow me to marry you. But I can't live without you. The boy says, same with me. If I tell my family that you're from Maharashtra, they will kill me. But I would rather kill myself than stay away from you. What should we do? Let's run away. Where do we go? Let's go to Tamil Nadu. You go to Tamil Nadu, approach the marriage officer. We want to marry. Okay, very good. Very nice decision. You look very good together. Where are you from? Sir, Karnataka. Okay, you're not from Tamil Nadu? No. Okay, you must be from Tamil Nadu? No, I'm from Maharashtra. No, then you can't marry here. Sir, what? See, if you want to marry under Special Marriage Act, then you have to give 1 month notice period. That is okay, but you can't register it here. You can register either in Maharashtra, where you are from, or in Karnataka, where you are from. Sir, but if we go there, they will kill us. Okay, so do one thing. Stay in Tamil Nadu for 1 month and then you can marry. But in 1 month, they will find out. We can't help you. If the boy is a Hindu, the girl is a Muslim, the easiest way they can marry then is convert into each other's religion. Because when you convert into each other's religion, there is no notice period. The boy and the girl both are from the same religion. Boy and the girl both are from the same religion. No notice period, no registration, nothing. They get married. So what is easier? Is it easier to convert into each other's religion, or is it easier to marry under the Special Marriage Act? A law, a beautiful law which was meant to facilitate interreligious marriages. It is creating hurdles. Further, even if this Tamil Nadu marriage officer says, okay, you can register this marriage here, but you know what? I have to send a notice. Notice to what? notice to Karnataka court where you are residing, your district court, notice to Maharashtra court where you are residing. I have to tell them, if you have any objections, you come to us and stop this marriage. If you have any objections, because what if you are already married? What if she is also already married? So we have to seek objections, which means what are you telling? Caste leaders, communal leaders, download Yatra, book your flight tickets, come to Tamil Nadu and stop this marriage. So it's like an open invitation. Download the booking app, book your tickets, book the train tickets, come to Tamil Nadu and stop this marriage. Which means, what this means is that marriage officers must send a letter to the permanent addresses of the parties, informing them that their son or daughter is about to do unthinkable, exercising his or her fundamental right to marry the person of your choice. It basically means invitation, making sure that parents as well as caste or community leaders are aware of the time, location of the intended marriage well in advance. The Indian state is like acting as a super khap panchayat, where the state decides whether you can marry or not. But there is something else. Hindus, for example, which includes Sikhs, Jains, Buddhists, if they marry a non-Hindu, whether boy or girl, they cannot inherit ancestral property. When this Marriage Act 1954 was passed, there were vehement protests in parliament, outside the parliament as well, particularly by the Hindu religious groups, saying you are trying to reduce the population of Hindus because Hindus will marry non-Hindus and then the non-Hindu population will increase. So Pandit Nehru, you are basically assaulting Hinduism. Pandit Nehru then clamped down and gave some concessions to Hindus. Said, we'll do one thing. If a Hindu marries a non-Hindu, he or she cannot inherit ancestral property. Now, because of that ancestral property, a Hindu will not marry a non-Hindu. Hindu will marry a Hindu. This basically means that this provision applies only to Hindus, not to Muslims, not to Christians, which primarily means that the Indian state hates the idea of interreligious marriage. Interreligious marriage should not be smoothened. It should be made very difficult. But particularly if it involves a Hindu, it gives Indian state a special heartburn. Then the state acts like a super khap panchayat, deciding who can marry whom and who cannot. And that's what now UP is doing. Madhya Pradesh is doing. If you want to convert, give 60 days notice. In some states, 30 days notice. And then you can convert. Which means you are converting because of marriage. Or you are marrying because you want to convert. We will not allow this. So first you have to give us a notice that we want to convert, so that we can see whether you were forced to convert or not. Then you can convert and then you can marry. Why should state be involved in this? This is a personal life of two consenting adults. Why should state decides who to marry, who not to marry, when to marry, where to marry? So we need to smoothen, simplify the procedures under the Special Marriage Act. That's how we can make it proper. And these acts are particularly against LGBTQ community. All the laws today, whether it is Special Marriage Act, whether it is Hindu law, whether it is Muslim law, whether it is Christian law, whether it is Parsi law, it says that you can marry. One of the partner has to be a woman, the other partner has to be a man. Forget about age. In Islam, you can marry once you attain the age of puberty, which is where you are capable of sexual reproduction, where your sexual organs develop. In other laws, the minimum legal age for marriage of girls is 18. For boys, it is 21. But then the requirement is one of the partner to a marriage has to be a man, the other has to be a woman, boy or a girl, which leaves members of the same sex ineligible to marry. In Navte Johar, Supreme Court said right to love is a fundamental right. Homosexuality is not a crime. But right, you can choose the person you love, but you cannot choose the person you marry, because you cannot marry the person of the same gender even today in India. That is why there is a petition filed in the Supreme Court. There was a petition filed previously in the Delhi High Court and in various other courts, asking the directive from the Supreme Court that all these laws should be amended so that people of the same sex, they can also be allowed to marry. Supreme Court said there is a case in Delhi, there is a case in Mumbai, there is a case in Tamil Nadu. All these cases, give it to us. Transfer these cases to Supreme Court. And now Supreme Court is hearing whether same-sex marriage would be allowed or not, which in all likelihood the Supreme Court will allow because of constitutional morality. That completes our discussion on Uniform Civil Code. Any questions? What is LGBTQ? Lesbians, gays, bisexuals, transgenders, queers. What is the minimum age at which a Muslim girl can marry? According to Prohibition of Child Marriage Act 2006, minimum legal age for marriage for girls is 18 and for boys it is 21. But according to the Muslim personal law, you can marry your girl when she attains the age of puberty, which can be 15 as well. Matter went to the Punjab and Haryana High Court. That on one hand, we have personal laws related to marriage. On the other hand, we have the law passed by the parliament, which prohibits child marriages. The Punjab and Haryana High Court said the Muslim girl can marry even at the age of 15, even if the law prohibits it. But then the Supreme Court said, we are hearing this matter, whether under personal laws, various communities can marry their girls below the age which is prescribed by the parliament, which is 18. This is now the Supreme Court's job. Now the Supreme Court will have to decide. Sir, if there is problem with notice period, why don't the government bring it down? Because they don't want interreligious marriages. Sir, do we need to remember all things in Special Marriage Act? Then, my dear, why are we discussing? It's not that it is the Valentine's Day and we are discussing laws related to marriage and divorce. This is part of the exam. Okay. Now let's look at one by one. All the other DPSPs mostly have been implemented. For example, Article 40 talks about organization of village panchayats. In every village, panchayat should be organized. We have implemented. 73rd Constitutional Amendment Act has been passed in 1992, where in all the villages, Panchayati Raj institutions have been set up. So even this DPSP has been implemented. Right to work, education, and public assistance in certain cases. Right to work, MG Narega, where if you belong to a below poverty line family in a rural area, 100 days of employment is your right. You have the right to work. Right to work, not for everybody. Right to work in certain cases. Right to education. In fact, we converted this directive principle into a fundamental right in 2002 when 86th Constitutional Amendment Act was passed. Public assistance. Give assistance to those during COVID lockdown who were not earning. We gave them food. The state gave them food. Public assistance in the form of scholarships. Even this DPSP we have implemented. Provision for just and humane conditions of work and for maternity relief. Do we not have Minimum Wages Act? We have. Do All the employers have to provide medical insurance to their employees. Yes. Does the law define under the Factories Act what should be the minimum hours of work that you have to do? Yes. And if you are working more than that number of hours, extra incentive will be paid to you. Yes. Maternity relief, for example, 26 weeks of paid maternity leave for 2 children. Have we not implemented this? We have implemented this. Similarly, Article 47, which shall be the duty of the state to raise the level of nutrition and standard of living and to improve public health. It's the duty. And when it's the duty, which means the state is taking steps to provide nutritious food, midday meal scheme to the kids, Janani Suraksha Yojana, Janani Shishu Suraksha Karyakram, all these important schemes which are trying to improve public health, which we will study in social justice. So all these schemes, all these programs, they are targeted at what? To implement directive principles of state policy. So even Article 47 we have implemented. Article 49, monuments and places and objects of national importance should be protected. Do we not have Archaeological Survey of India, which takes care of all these ancient monuments? We have it. We take care of them. Similarly, separation of judiciary from executive, Article 15. We have implemented it in 1973. Similarly, promotion of international peace and security. We don't go to war. Throughout our history, we have never initiated war against our neighbor. China did it to us in 1962. Pakistan did in 47. Pakistan did it 65. Pakistan did in 71. We did not. Pakistan did in 1999. We did not. So throughout our history, we have not initiated war with any other country. So forever and ever, we are in the interest of promoting international peace and security. That is the directive principle. So basically, all these DPSPs have been implemented, except Uniform Civil Code, which we have discussed. And then there are some DPSPs which we have implemented, but to implement them fully becomes difficult. Why difficult? We will discuss that tomorrow. And tomorrow we will discuss the significance of directive principles of state policy as well. It will take half an hour. Then we will jump to fundamental duties. And then the most important case in the history of independent India, Keshavananda Bharati versus State of Kerala, 1973. We will discuss the doctrine of basic structure. Clear? So what is Article 37 define? Article 37 talks about two characteristics of DPSPs. That these DPSPs are not enforceable in a court of law. Nevertheless, it shall be the duty of the state to implement directive principles because they are fundamental for the governance of the country. What is Khap Panchayat? For example, in Haryana, group of villagers, they decide whether a person can marry or not. You cannot marry the person of the same gotra. You have to marry outside the gotra. So this is an extra constitutional body, not mentioned in the constitution. Basically, unconstitutional body. It should not have even existed. That means to impose restrictions on the people, the group of people come together and become like a panchayat, a khap panchayat. Sir, please take my question. Asset was managed by husband after divorce. Even before divorce, the communion of assets, the manager is the husband. Sir, do we need to study in detail every judgment we studied in Article of Fundamental Rights? Whatever we study in the class, you have to remember it. You will have to understand it. All the judgments, because look at the mains question papers now. They ask you substantiate your answers by citing relevant case laws. So you'll have to cite case laws in your answers. Okay, that is it for today. See you again tomorrow, 6 o'clock in the morning. Till then, have a great time. Stay safe, stay healthy. Should you have any doubts, get in touch with the subject matter experts and they'll be happy to resolve. And today's class, whether you liked it or not, let me know. You'll have the option of rating the class as well. See you tomorrow, 6 o'clock. Till then, bye bye. Take care.